Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
We will bring the jury.
9 out of 10 judges prefer watching the Recovery Addict's live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. I didn't ask you to interrupt.
Is that correct?
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Friday. Welcome. Good to have you all here. Come on in, have a seat. Take your seats. Everybody down in front. Fran Fitzgerald. Welcome, Fran. Good to have you here. We are we're gonna need you today. We need you to carry all the weight of the internet. Everything IP related worldwide is your responsibility, Fran. You've won again. Congratulations. That's what being first in chat will do to you. All right, yeah, everyone's getting renamed to Pen in honor of the great red pen. Pale pink pen is here. Oh wow, we've got lots of pens here. Blue pen, yes. We've got all the pens. So does my wife, by the way. My wife has all the pens. She likes doing journaling. Like when I say journaling, I'm not like writing down what has happened. She writes down what is going to happen. Planning. And she does these books. She's got books and books full of like stickers and washi tape and designs and colors and fancy stuff. Pretty cool stuff. All the pens. She has them all. So welcome. Let me tell you what's on the schedule today. We've got a little bit of fun court hopping that's going on. We've got a spicy one here in just a moment. There's a hearing this afternoon for the one, the only Corey Richins on all the other charges. This is other cases coming up. We're not allowed to live stream that one, but I will have the feed available for me so I can tell you what's going on over there. We'll keep an eye on that and watch that. We've got some court documents we can dig into. Obviously, the Lindsay Clancy thing is going on over there. Jury verdict watch, and they come back with a question. The judge won't tell the public what the question is. They took the question in chambers. Who does that? Your Honor, come on. Anyway, the Mrs. predicts the future. She doesn't just predict. She plans. She plans the future. Let's see. So boring court watch over there, but we're gonna have some fun over here. We're gonna try to have some fun. I will say this. I know that there are a number of people, good friends of the channel, who are going through some very, very difficult times.
Remember in the beginning when we started 110 years ago?
Today, with heavy things going on. Thomas has some stuff going on in his life with some very dearly loved pets that are just not doing well at all, and multiple, I think 3 of them, that they're having problems with, and we've got individuals like Britta, who has her mom in an emergency situation in the hospital right now. Please just be mindful of all those people. I know there are many others of you who are going through very difficult challenges of your own, and to do it in silence and just come here for a break. I'm mindful of that. I'm very mindful of that. I appreciate you bringing your kindness here, even in moments that are heavy for you. So it's a great reminder to the rest of us to treat each other just nicely and kindly, because we don't truly know what anyone else is going through. A couple times we hear a little bit about what's happening, but pretty much everybody has something that's heavy that they're carrying, sometimes alone. So please, lift somebody up today. Smile. Voice is low. Yeah, I'm I'm mellow. That's my drama voice. I'll turn the voice up just a little bit and talk a little bit louder as well. So, oh man, yeah, we've got poor Melissa as well. Lots of that. We have that. We have birthdays is what we have. We have birthdays to sing to. Lois, thank you very much for putting this together. We've got, pretty soon we're going to sing to all the colors of the rainbow and then Penn at the end. That's how I predict this ending up. But we are going to sing happy birthday to some wonderful people who have their birthday either today or tomorrow. And looks like we have Joe, Joy, Karen today, and a pink swan. I think just one pink swan. I don't think the pair of swans, but a pink swan tomorrow. Is there anyone else tomorrow? Let me know. We can add it late if we need to. But we're going to go ahead and sing to these wonderful people. By we, I mean all of us, not just me. So wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room.
Birthday.
Blend your voice with your neighbor and warm up with me if you will. La 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 la. I got it this morning. I'm feeling it. Happy birthday to you. Happy birthday to you. Happy birthday to Joe, Joy, Karen, and a pink swan. Happy birthday to you. Woo! Joe says, I've waited a year to have you sing to me happy birthday. All right, Joe. That's a long year. That is the standard waiting period, though, if you just missed it. So, but I'm glad it's over. Happy birthday today. Happy birthday. I realize there are many wonderful days. Today's your special day, and there are a million places you could have been and a billion people you could have been with, but you chose to be right here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can return that joy right back to you. Make your day just a little more special, or begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Eddie's Grill, Bob Evans,
You look good.
and Cracker Barrel. Woo! Me, the 30th Gracie. We have to sing to Gracie, too. We'll probably sing to you on Monday as well, Gracie. Because it'll be the 31st. Does August have a 31st, or is it just 30? These are hard math questions. I don't know. We'll sing anyway. Happy birthday to you. Happy birthday to you. Happy birthday, dear Gracie. Happy birthday to you. There you go. There you go. In case we miss you on Monday, yes, we get a 31st on Monday. Excellent, Lois. Thank you for doing the math and for keeping track of all this. We'll sing to you then as well, so we can celebrate all weekend long. All right. Y'all sound marvelous. Isn't it beautiful? All around the world, people are singing happy birthday to you right now. Okay, we're going to do a drum solo for a big finish. Ready? The camera angle makes it hard to hit the drums the same. Beautiful. Thank you. Dancers did great as well. Fran. No, you were just out front. You were out front. Everyone was dancing behind you. You were just leading the group. We're going to start off today with a little bit of court, a little bit of weed. We're going to start off with a little bit of weed. What a way to start the weekend, right? We've got a weed court going on, and the judge gets frustrated. I don't know how else to say that. The judge gets a little frustrated here. So let's listen in and see how that goes. Morning, Your Honor. You ready? Judge Ramsey, you ready?
Looks like Trevor Tribble didn't appear today.
I don't see him.
Yeah.
Jason Tinsley, if you can hear me, please unmute and start your video.
Yes, ma'am.
Thank you.
Unmute,
all right. The attorney came into your room and said she was not getting a response. So I'm going to tell you what the offer is here. This is ticket number P1925144. Can you get to a place? Are you sitting, please?
Yes.
Thank you. Ticket number P1925144. This is City versus Jason Tinsley. State your name for the record, Mr. Tinsley.
My name is Jason Chase Tinsley.
Thank you. You've got 3 tickets in front of me: driving the wrong way, open alcohol driver, and improper transport of marijuana. They are offering to dismiss the first 2, driving wrong way and open alcohol. That would save points on your driver's license as well, and have the improper transport of usable marijuana under a 3-month delayed sentence, which means that after 3 months, if you don't get any similar tickets and you pay the fine of $190, this will simply be removed from your criminal record. Do you understand that?
Yes, I do.
Do you want to avail yourself of that offer?
Yes, I would.
Okay, I need to advise you that you do have the right to a trial. At a trial, you would have a right to see, hear, and question witnesses against you. You'd have a right to have a subpoena witnesses on your behalf. You'd have the choice to testify on your own behalf or to remain silent. If you chose to remain silent, the government could not make any comment about that at trial. Finally, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those would be your rights at a trial, Mr. Tinsley. Do you understand all of that?
Yes, ma'am.
And do you understand that if I accept your plea today, there won't be a trial, so you will not have those rights?
Yes, ma'am.
Please raise your right hand. Do you swear to tell the truth?
Yes, ma'am.
Thank you. Is it true that on June 28th of 2026, in the area of East Grand River and Farmer Street, you were improperly transporting a usable portion of marijuana above the legal city limit in your vehicle?
It was all usable.
Yes.
Okay. Were you in a vehicle on June 28th of 2026?
Yes. Yes.
Was that vehicle in the area of East Grand River and Farmer Street at that time?
Yes.
And were you the driver or passenger of that vehicle?
Driver.
And did you have marijuana on your person at that time?
In the vehicle. Yes.
Thank you. All right. Do you know how much marijuana you had in the vehicle?
No.
Okay.
Some.
I mean, was it enough to use one time? Was it enough to?
Probably 3 times.
Okay.
3 times a single-use dosage. Alan's frustrated with whatever his computer's doing. It's not what he wants it to. Bo's Quick Lube there's a customer out there waiting for an oil change. And Jason is going to get right on that in just a moment. Three blunts.
Where was the marijuana located?
Scattered on the floor, I think.
He dumped it.
And how old are you, sir?
24.
Okay. And so,
he's not sitting down anymore.
Do you dispute that you had more than 2.5 ounces of marijuana in the vehicle?
I'm sorry, how much?
It's 2.5 ounces that you're allowed to legally transport. So the allegation is that you had more than 2.5 ounces in the vehicle.
Oh, no, I didn't have that much.
Okay.
I don't remember, but I don't think I had that much. I never had that much.
Okay. So we can set the matter for trial. If I set it for trial, they will have to come and they'll have to prove that the amount was over the legal limit. I don't know how they plan to do that, but I can set it for trial if you wish for me to do so.
They would have had to gather it up and weigh it.
I don't know. The only thing is...
But you did say you don't remember. Hold on. You said you don't remember. So if you don't remember, which might be explained by all the charges that are in front of me today, you don't remember. If you have a lack of memory, we can take this as a no contest plea if you don't remember. Alternatively, you do have the right to trial, and you can go to trial, at which point they would have to prove that you had enough, but you would lose the benefit of the delayed sentence.
And I would also lose the cancellation of the other 2 tickets.
Yeah.
Correct. Mm-hmm. So if you'd like me to take this as a no contest plea based upon your lack of memory, I can do that.
And
that means you're not
admitting
guilt. You're just saying, I don't remember. If they say I did it, I did it. They've got enough there to say, to convict me. So I'll just let it. I mean, that's really what you're saying in a no contest plea.
So it's pretty much the same thing as the taking the plea?
Yeah, it has the same effect. Same $190, same 3-month delayed sentence. Just we're not taking deeply because you don't remember.
Okay. Well.
Okay. So you've stated that you have a lack of memory of that date and location of the stop. Is that correct?
Oh, that's where the stop was.
Okay, but do you remember the details of the stop or the amount? You said you were lacking memory about something. So I'm asking you, do you not remember exactly how much marijuana you may have had in the vehicle? Is that what the lack of memory is?
That I did have less than 2.5 ounces.
Okay, then we're going to set this matter for a bench trial. I mean, I can't, if your lack of memory is the reason that I'm not having you admit guilt,
right?
And that's why you want to be able to take no contest. You can't stop talking. Stop talking. You can't keep telling me I don't remember, but I remember everything that's beneficial to me. I don't remember, but I didn't do it. I don't remember, but I didn't have it. Either it's that you don't remember or you do.
I'm sorry for interrupting you. I remembered that there was multiple packs in the car. I've never had 2.5 ounces on me.
Okay. So again, I don't have any basis upon which to take a no contest plea. The law is very clear. I cannot take a no contest plea just because. There are certain reasons that I can take a no contest plea: lack of memory, civil liability, another one. But I have to have a reason. And what I'm saying is, when you told me I don't remember, that's a reason. Fine. But every time I start to ask you a question, you keep telling me everything you remember and that you're not guilty, which is also fine. But that means we're going to set the matter for a bench trial. So either you remember or you don't. I'm not in your head, so I don't know.
No, I understand, ma'am. I'm sorry for the confusion. Can I just take the plea?
Okay, here's what I'm going to do. I'm putting you back in the breakout room because part of the problem is the attorney said you weren't responding. So now I've got to move you so you can speak with her again. I'm going to move you up to room 5. Please go to room 5. She'll be with you shortly.
Yes, ma'am. I apologize.
That's okay. All right, Attorney Soroki, we're ready on Mr. Perry?
Yes, Your Honor.
Thank you. Mr. Perry, please unmute. Start your camera.
I was going to take the deal, but then I got high. Would have waived my right to appeal, but then I got high. Now the judge is yelling. I don't know why.
Showed up late and I never did.
Because I got high. I'm going to get copyright strike for that.
I'll call it from the docket. What time's Mr. Perry? Oh, he's 9:30. Okay. Thank you. Calling ticket number P19111. I'm sorry. Oh, it's hard to read. So many ones. P1911117.
That's a lot of ones.
And P1911107. Both of these are City versus Alex Perry. Counsel, your appearance, please.
Good morning, Your Honor. Alan Sroki, P37441. Appear on behalf of the defendant. What's your full name for the record, sir?
Alex Perry.
Your Honor, at this time, today's the date and time set for trial. The police officer has appeared. Defendant wishes to accept the offer of the prosecution in this matter. Mr. Perry will plead to the charge of, let's see, driver while licenses. Let me see. I just put this file down. I'm sorry.
6 to 9 over 9.
Mr. Perry, why are you talking?
Oh, sorry. Yeah. Okay. I'm sorry. I just had this offer in front of me.
Just give him a minute, Mr. Perry. He's got probably 20 cases this morning.
Okay,
He's just pulling.
Perry.
I was just trying to help him out. Okay. Yes, ma'am.
Okay. Let him do it.
Yes, Your Honor, defendant's pleading to 6 to 10 miles an hour over the speed limit as reduction from the 11 to 15 over. The remaining tickets are being, 3 tickets will be dismissed.
Pretty good deal.
Okay, now, Mr. Perry, is that consistent with your understanding?
Yes.
Okay, thank you. We all have a job that we got to do. Okay, so I need you to do yours. We're going to do ours. So 6 to 10 over is a $135 ticket. It does put 2 points on your license. You're aware of that?
I am now.
I am now.
So you would be admitting that on May 8th of 2026 in the area of southbound Livernois and Clifton that you were going at least 6 miles per hour over the posted speed limit?
Yes.
Okay. It's $135. You have 60 days in which you can get it paid. If you can't get it paid in the 60 days, you can get on a longer term payment plan with the cashiers on the first floor, but they're going to want a down payment from you before you do that, and you have to at least get that done within the 60 days, okay? Okay, have a good day. Thank you.
Judge, you're having a day.
I don't know. I tried to bring Officer Hill out.
Officer Harold Hill?
Yes, Your Honor. I forgot to ask you to bring him out. There's about 3 more defendants that are in odd breakout rooms that have trials that don't have an attorney. I'll just hang out with them and help see what I can do to get those cases resolved.
Thank you. Now, Jason Tinsley in room 5 has not been seen by counsel because he was not
I'll see him.
responding.
I'll go talk to him right now. Thank you.
Let's just wait here. I want to see how this ends. It's nice and quiet right now. Yeah, this judge is, she gives everyone anxiety, I think.
Hey, Longoski, Preston did not appear. We'll go ahead and issue the warrant.
Okay, thank you, Your Honor. I wasn't sure. It gave me an error and kicked me.
FTA,
Nope. Have a
that's
great
warrant.
day.
Thank you. You as well.
Bye.
I wish she hadn't muted. This is the good conversation right here. What's she drinking? Prime? She's about to pour it on herself if she doesn't hold it up right. Okay, here she comes. Nope, we're panning over. Ah, she doesn't want to. We don't want to. She doesn't want us to see her drinking whatever it is she's drinking. Glug 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 glug. I should learn to read lips. I think she knew we were watching. Kaylee Rose, the jury questions in Clancy, they're not telling the public about. So we won't know until it's all over, I guess. Let's see. Now she's done drinking. We get to pan back over. Oh, and eating as well. There we go. So many buttons. You're gonna break the remote, ma'am. That's remote abuse.
I think this is changed.
Was that a Nintendo sound I just heard?
A lot of it is the
That's the duck hunt.
It's just a crazy day.
Yeah, it is.
A really crazy day today.
She has zero patience. I hope you're not on her docket today. She said this docket is just nuts today. And she gone. She gone. Well, we can fast forward. I should have done that. Well, she's back. What are we looking for? Glasses. Badge. Badge. We're looking for a badge. Okay. You have to open the door with a badge. Mr. Murray, you just missed her. You're so close. Let's see when she comes back.
Officer Hill.
Wait.
What's going on? Nobody ever came.
Okay, well,
We shouldn't have skipped this.
make you.
Back up. We're going to back up. Apparently the mics are still on, so we'll see what happens. Mr. Murray's here. This one we skipped. But sound comes on in just a moment.
Attorney Murray, the judge just stepped away. Are we going to be ready on your case?
I already told him.
I'm trying to figure that out now. I've been searching for the city attorneys. I know.
Well, I know she's in room 2 right now. Oh, and I still, you came back and I can't make you co-host, but I know she's in room 2.
They stepped away. There was 2 city attorneys, and neither one of them have been able to get to me. So let me try to go back.
Okay. Attorney Ragnar, are you having the same problem trying to get the city?
Well, and we've talked back and forth, and then they've been called to other areas. So that's not a problem. I was just checking back in because I do have one case to ask for a dismissal. If the court wants me to do that now, or I can just come back when I do the other cases.
She just stepped away, but she will be back.
Okay, well,
a second.
I mean, no rush here, okay?
Don't page the judge on my behalf. We know she's not in a good mood.
I know how she likes to keep moving along, so.
Yes, and it's been a long morning. Let's see who this is.
The best thing you can do.
I can just come back.
Yeah, that's probably.
Okay. Good morning on the iPhone. What's your name?
Jerome Tyson. I was in a breakout room, but I've been in the breakout room since 8:45. I didn't know what was going on. Nobody ever came.
Since 8:45. It's 11. Evangeline Light.
I had got back off and then got back on.
OG, 40 months. Not sure where the time's gone, but I wouldn't trade this time in the community for anything. Thank you, RA and the mods. Thank you, Evangeline Light. It wouldn't be the same without you here. Congratulations on 40 months.
Officer Hill?
Yes.
We took care of the Alex Perry. He took the, I know it was a reduced in the speeding charge, something like that.
Yep. Thank you.
So you're good. You're welcome. Mr. Tyson, I'll put you in another breakout room. I don't know. The attorneys are trying to speak with the city prosecutor now, so I don't know if they were.
She came in the breakout room at probably 8:45 when I first got in there. They sent me in there, told me it was 5 people in front of me. She came in the room and told me that she was about to talk to somebody about my case and come back.
Okay, so it was the female attorney, so I'm going to put you in breakout room number 7.
Okay.
Zoom has
She's
really.
in there speaking now, so maybe that's what she's speaking about. I don't know.
Okay.
So we're going to just stick you in there. We're just going to throw you into whatever meeting they're having with between counsel. Yeah, Zoom has complicated court processes for a couple of courts, and I think this is one of them. What is that little attachment on the back of the monitor? Is that a camera?
Oh, I know. He had a ticket in default. That's where he was at. That's probably what she's speaking
Peter Tupperware also hitting that big 4-0. 40 months. Oh, gee, been watching the LC trial. I'm happy it's almost over. We'll be happy to come around and come back to normal. Peter, we've saved a spot for you. Thank you. Enjoy the verdict watch. Hope you get the outcome the justice demands.
Madam Clerk?
Yes.
Harmony Perry, I'm not sure if she's left or if she's still in the courtroom or she.
I don't know either. I don't see her in any of the breakout rooms, but I believe you can do an officer on her behalf because she was here.
Yes, and I did talk to her, so I will. Thank you very much.
Okay, judge is back.
I think the judge had a little smoke break.
No officer on Harmony Perry, but she was here.
Miss Perry was, yes, she did check in, I know.
Yeah.
Okay, are we muted or unmuted?
Unmuted.
We're unmuted.
Perfect. Okay, calling ticket number P1891558, City versus Harmony Perry. Counsel, your appearance, please.
Good morning, Your Honor. Samuel A. Ragland, P23-157 on behalf of Miss Perry. As you mentioned, she did check in, but she is not here now. The officer, to my understanding, has not appeared, so I'm asking the court to dismiss this.
Motion to dismiss for no officer is granted. Have a good day. Well, you've got more cases with me, I think, today.
Well, have a good day. You have a good day as well.
All right, thank you. Okay, Attorney Murray, are we ready on yours?
Unfortunately not, Your Honor. I'm waiting on Attorney Horn, I believe. I've been going back and forth with the city attorneys, but haven't had any luck. So I'm just going to sit tight.
Have you spoken with Attorney Horn?
I have. I've spoken to both of the city attorneys briefly, but we haven't gotten anywhere.
Okay, let attorney, make sure you're texting her, whatever, letting her know that you're waiting to speak with her because she's working in another courtroom.
Okay, we'll do.
All right, good to see you.
Hey.
Thank you. Harmony Perry, good morning. Your case was just dismissed for the officer's failure to appear. Your attorney will let you know.
Okay, thank you.
You win.
You're welcome. Have a good day. Bye.
You win. The judge is already shaking her head. You just came back from break here. She's already frustrated with the system.
That's what I'm saying, like.
She does not like being on camera. It's okay. We can just fast forward to when you're back on camera. Here we go.
Okay, we ready on Tinsley?
Yes, Your Honor.
Here we go. This is the conclusion to what we were starting. The weed case. He was offered 3 months with delayed sentencing.
Calling ticket number P1925144 and all other related matters on today's docket to City versus Jason Tinsley. Attorney Soroki, your appearance, please.
Yes. Good morning, Your Honor. Alan Soroki, P37441, appearing on behalf of the defendant. What's your full name for the record, sir?
My name is Jason Chase Tinsley.
Thank you. Counsel?
Yes, Your Honor. Defendant wishes to accept the offer of the prosecution in this matter.
There you go.
First of all, as to the arraignment, defendant waives formal reading, stands mute at this time.
Court notes formal reading has been waived. Enters a not guilty plea on your client's behalf as to all charges.
Thank you. Defendant wishes to accept the offer of the prosecution. He will plead guilty to the possession of marijuana or transportation of marijuana and vehicle charge with a 3-month delayed sentence, and then the open alcohol driver charge will be dismissed.
All right, thank you.
That's the bigger charge.
Now, Mr. Tinsley,
thank you, Judge.
Well, Mr. Tinsley, this is consistent with your understanding, the 3-month delayed sentence, dismissal of all other charges?
Yes, ma'am.
Did anyone promise you anything else to get you to plead guilty today?
No.
Did anyone force, threaten, or coerce you into a guilty plea today?
No, Your Honor.
Are you pleading guilty because you are guilty?
Yes.
Did counsel advise you that you have the right to a trial and the rights that you would have at a trial?
Yes.
Yeah.
And you understand that you won't have those rights if I accept your plea today because there will not be a trial?
Yes, ma'am.
Please raise your right hand.
Spread your fingers
You
out
swear
wide.
to tell the
There you
truth
go.
today?
Yes, ma'am.
Thank you. Attorney Soroki, if you could unmute, I have a date and location of June 28th, 2026 in the area of East Grand River and Farmer Street. Would you please complete the factual basis?
Okay. Mr. Tinsley, were you operating a motor vehicle in the city of Detroit at that date and time?
Yes.
Okay. And did you have marijuana in the front in the passenger or driver's area of the car at that time?
Yes.
Okay. That's defense is satisfied, Your Honor.
All right. Thank you.
I don't know. I think this guy should have gone to court. I know he would have brought the other
Mr.
two tickets on
Tinsley,
him, but I
your
think he
fine
could
is
have
going
beat
to be
that.
$190. You have 90 days to get that paid. As long as you pay it off in the 90 days and you don't get any similar tickets, we'll just pull this up and dismiss it from your record. If you get
Yes,
another ticket like this, you're going to have to come back and see me in 90 days.
I do have one question. What do you mean by similar ticket? Like just the same thing?
Yeah, if you get another marijuana ticket, improper transport of marijuana, then you'll put your delayed sentence in jeopardy. So be careful.
Okay. Okay, I get you.
It's our 90-day date, Madam Clerk. Please.
November 30th.
Okay. So if you need to come back and see me because something goes wrong, that's November the 30th. As long as you pay the $190 and don't get any more of these, by November 30th, we'll just pick it up, pull it up, and dismiss it from your record. Okay?
All right. I greatly appreciate you, Your Honor.
Have a good day. You too. Bye-bye.
Yes, well.
I feel like I got tennis elbow from Aaron.
Okay. Let's see here.
Just mute him.
Are you done? Let's see here. Bum, 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 bum. Judge. We've got Judge Webster. Judge Webster. Here we go. Hop, skip, and a jump. Oh, Greenwood County Jail. I think we've seen him before. In Judge Webster's. He looks really familiar. Maybe it was his doppelganger. Judge Wolf in Tennessee is doing his thing. Let's see. Judge Stevens. Judge Stevens looks like he's got a wedding.
Communication is less. Usually when I communicate with her to make sure she knows her court dates are coming.
No, not a wedding. Not a wedding. Never mind. I thought I saw somebody in white back there, but it's just my eyes playing tricks on me. Let's see. Judge Middleton's doing landlord-tenant, and he's also hard to hear. We can go back to jail court. Jail court. This is fast. This is a fast one.
Since it's a Class C misdemeanor, okay? You're free to go make your phone calls. Andrew Koppel. No, you have to make bond on this one. Okay.
We'll talk to you after, Jake. Thank you.
All right, Mr. Koppel, you have a warrant out for you in cause number PFF 2026 WNT 0117 for a third-degree felony assault against a family or household member with a previous conviction alleged to have occurred July 4th of 2026.
4th of July
that bond's
fight?
been set at $50,000. In addition to the bond amount, there are conditions of bond that have been entered against you, and these are those conditions that you abide by the conditions of bond. You commit no offense against the laws of this state, any other state, or the United States. You avoid persons or places of disreputable or harmful character. You will remain totally abstinent from the use or possession of alcohol, narcotics, marijuana, drugs, dangerous drugs, controlled substances, or any other intoxicant unless prescribed. You'll submit non-dilute samples for testing of drugs, alcohol, and other substances at the direction of the pretrial services officer. You'll be added to the UA call-in line. You'll attend and complete any counseling or rehabilitation as recommended by your officer. You'll not possess any firearm or other weapon. You'll report in person to Lubbock County Pretrial Services before 11 a.m. on the first business day following your release and bi-weekly thereafter. You're ordered not to have any contact directly or indirectly or communicate with Holden Koppel or go within 500 feet of any residence, school, place of employment, business, or location frequented by him. You're to remain at your residence located at 10.
We don't need to know where his residence is.
Except to travel to and from your place of employment, attorney's office, and other essential places as approved by the pretrial services office.
That's not my residence, ma'am.
Okay, then I'll change it in a second. You're to be home between the hours of 8 p.m. and 6 a.m. unless prior approval has been obtained.
No nighttime
parties. You will
parties.
have a GPS
No
monitor
shenanigans.
placed on your person prior to being released from this facility. You'll submit to outpatient or inpatient mental health treatment for intellectual or developmental disability or mental illness as recommended by the local mental health authority. You're to report into your attorney's office every 2 weeks in person or by phone while on bond. And then there is another condition that's a little lengthy, so I'll allow you to come up here and read it.
And while he's coming up and reading that, I'm going to show you the world's longest yawn by the guy with the great
any
beard.
questions
You ready
so
for
far?
this?
Yeah.
World's longest, biggest stretch and yawn. Check this out. It's coming on. You can feel it. The little tingly comes. Here goes. Here goes. Oh. Big stretch. Big stretch. Oh, wow. And a full body stretch. Arch the back. Whoa. Man. It's hard work waiting for court. I'm sorry. That's all.
Yes, ma'am.
Okay, and the zip code.
I just saw him. He's tired. I'm tired too. I feel it.
And then here's the other condition that's a little bit lengthy.
This judge does not read long conditions.
Okay, so I'm gonna have you put your date of birth there and your signature there, stating you understand them. You can speak to an attorney about these conditions and they can advise you from there. Do you want a court-appointed attorney?
So I don't know if this is in the scope of what you can answer. I can have an attorney modify those conditions, or that's just
Well, they can speak to the DA's office about those conditions. Okay, you're free to go make. Manuel De Leon?
Work this one. Sure. Thanks. No, it's all good.
All right, Mr. De Leon, you have a bond forfeiture in cause number DC 2026 CR 1281 for a state child felony possession of marijuana between 4 ounces and 5 pounds. That bond's been set at $5,099. And I show Taha's representing you. Do you have any questions? You're free to go make your phone calls. Edgar, is it Escarcega?
Discussing.
And sir, you've been charged with the state jail felony theft between $2,500 and $30,000. I do find probable cause for that charge and set your bond at $2,500. Do you want a court-appointed attorney?
No, no.
Are you a U.S. citizen?
I'm a permanent resident.
Okay. What country are you a citizen of? Where were you born?
Mexico.
Okay. Would you like me to notify the Mexican consulate of your arrest? It's up to you.
Maybe you don't have to, no.
Do you have any questions?
No, do I just call the bond or?
Yes, you can call a bonding company unless you have $2,500 cash. You can do that either way. The bonding company will charge you a percentage of the 2,500. So you're probably looking around 375 or so to get out of here, but just call the bonding company and they'll let you know for sure. You're free to go make your phone calls. Marvin Gonzalez. Ms. Gonzalez, you have a warrant out of Justice of the Peace number 2 and cause number J2 2022 CR 0977 for a Class C misdemeanor possession of drug paraphernalia. That bond's been set at $200. We don't appoint attorneys on Class C misdemeanors, but you can always hire your own. Do you have any questions? All right, you do have a few city tickets, so if you'll have a seat, that judge will be right with you. David Jimenez. Mr. Jimenez, you've been charged with a state jail felony, possession of marijuana between 4 ounces and 5 pounds. I do find probable cause for that charge and set your bond at $5,000. And I do show Matt Morrow's representing you on some other matters, so we'll appoint him as your attorney on this case.
Appreciate
Do you have any questions?
I don't have no hoes in it to rock bond.
Not at this time. You're free to go make your phone calls. You're welcome. Justa Keeling. Did I say your name right? Okay. Sir, you have a warrant out of Justice of the Peace number 4 and cause number J4 2025 CR 0941 for a Class C misdemeanor driving while license invalid. That bond's been set at $50. We don't appoint attorneys on Class C misdemeanors, but you can always hire your own.
Okay.
Any questions?
No.
You do have a few city tickets. You need to see that other judge. So if you'll have a seat, she'll be right with you. George Marmolejo. Sir, you have a warrant out for you and cause number PFF 2026 WNT 0112 for a 3rd-degree felony violating a protective order 2 or more times within a 12-month period, alleged to have occurred July 8th of 2026. That bond's been set at $300,000. In addition to that bond amount, there are conditions of bond that have been entered against you, and these are those conditions: that you abide by the conditions of bond until disposition of this case. You commit no offense against the laws of this state, any other state, or the United States. You avoid persons or places of disreputable or harmful character. You maintain total abstinence from the use or possession of alcohol, narcotics, marijuana, drugs, dangerous drugs, controlled substances, and/or any other intoxicant unless prescribed. You'll submit non-dilute samples for testing of drugs, alcohol, and other substances at the direction of the pretrial services officer. You'll be added to the UA call-in line. You'll not possess any firearm or other weapon. You're to report in person to Lubbock County Pretrial Services before 11 a.m. on the first business day following your release and bi-weekly thereafter. You're ordered not to have any contact directly or indirectly or communicate with Marcy Moreno or go within 500 feet of any residence, school, place of employment, business, or location frequented by her. You're to be home between the hours of 8 p.m. and 6 a.m. unless prior approval has been obtained. You're to have a GPS monitor placed on your person prior to being released from this facility. And the victim will receive notification when the GPS locates yourself near her home, place of employment, or school.
Good.
Do you have any questions about those conditions? Do you want a court-appointed attorney?
Yes.
Carlos Chambers.
Okay, are you hiring him?
I've already talked to him.
Okay, so you're going to hire him? Okay. All right. I am going to have you come up here and sign these conditions of bond. Your signature states you understand them.
Yeah. He's probably not going to take that out of his commissary account.
They will come and interview you and put that paperwork together for me to review. Okay. All right. If you'll put your date of birth right here.
All right, let's. We've seen a little bit of this. It's sort of rinse, wash, and repeat with these guys. Let's
anywhere in the vicinity will be fine. Yeah, that's perfect.
Let's jump up to Judge Webster, who's handling business right now in Kansas.
McCoy, I'm going to order that you come back November 6th at 10 a.m. And let's see. We had a motion for judgment for forfeiture of the bond filed May 8th. We resolved that. Failure to appear bench warrant May 8th. Bond posted May 26th. order of the appearance bond, return of arrest, bench warrant. So it looks like that was all set aside, so we don't have to deal with that anymore. So I have approved the $15,000 bond with Florio that you posted May 26. I will continue that again with the added condition that you reappear November 6th at 10 a.m., sir.
Okay.
Thank you. You are excused at this time.
Give me a call, Corey.
I will.
Judge Chad Smith, please.
We are on the record in GW 2026 TR 568, State of Kansas versus Chad Smith. Please announce appearances.
State of Kansas appears by and through Assistant County Attorney Paul Ayden.
Your Honor, Blake Cooper on behalf of the defendant Chad Smith, who appears in person.
Someone's phone's ringing.
And how does he wish to proceed, Mr. Cooper, on this one count of driving while suspended?
Judge, Mr. Smith is very, very close to having his license fully reinstated. We just need some time, and I think we'll have that done soon. I don't know that we need the November 6th date, but if that's the only one, we'll take it, and that's fine.
Missy, can you add another one to November 6th at 10 a.m.?
Yes.
All right, Mr. Smith, you're ordered to reappear by Zoom November 6th at 10 a.m. You did make an appearance bond that was filed July 6th of 2026.
Hello.
And I will continue that bond. That would be a $2,500 bond that you posted with Don Kirkman of Butler County Bail Bonds. The added condition to that bond is you reappear November 6th at 10 a.m. Any questions about that, Mr. Smith?
Apparently
Mr. Smith, do you hear me, Chad Smith?
Like maybe he's frozen, Your Honor.
Well, I thought he was, and then he kind of moved a little bit. Chad Smith?
He's been gone for a
Mr.
while.
Cooper, can you make sure he's here at that date and time?
I sure will. Yeah, it looks like he's. Oh, yeah. Chad's in very good contact with me, so I'll contact him after court, Judge.
He's probably one of those Greenwood County positions where the signal isn't very strong. Mr. Smith?
Can you give us a thumbs up if you heard us, Chad, about the date?
Can you guys hear me now?
Yeah. We can. Okay. Did you hear us?
Yeah, I'm out in December.
All right.
Okay.
Very good.
Delayed
You're back here November 6th at 10. You may go.
Thanks.
And Judge, well, Paul, I don't know if we talked about Jamie Joseph. I do need to request a continuance on too. I can't remember if we covered that one.
No, but that's fine.
Okay. Could we take up Jamie Joseph, Judge?
If she'll start her audio and video, Miss Joseph, thank you.
There she is.
We are on the record in GW 2026 TR 512, State of Kansas versus Jamie Joseph. Please proceed.
Jamie.
Appearances.
State of Kansas appears by and through Assistant County Attorney Paul Ayden.
Or Jamie.
Your Honor, Blake Cooper on behalf of the defendant Jamie Joseph, who appears in person.
And how does she want to proceed, Mr. Cooper?
Your Honor, Ms. Joseph and I have played a lot of phone tag over the last month, and it just haven't worked out to get us together. I have since this morning, in talking to her, we've scheduled an appointment to get together. She's got a little bit of a more complicated issue, so I'm asking for a continuance to give us time to talk about that case and to determine which direction we want to go.
Missy, can we do November 6th at 10 a.m. for this one?
Yes.
All right. Ms. Joseph, can you hear me?
Yes.
I'm going to order that you reappear November 6th at 10 a.m. and I'm making that a condition of your bond that you previously posted and was filed on June 16th to 26th. So make sure you're back here. Make sure you talk to your attorney about whatever he needs to talk to you about so he can represent you. You may go at this time. Thank you.
Thank you, Your Honor.
And then, Judge, at this time, I'm just going to need to have a series of breakout rooms with the other individuals so I can determine where we're at with these. I think a few of them will be for plea, but I need to check.
What about the one that Carlos is here for Spanish interpreter? Do you want to take?
Yeah, I could talk to him first and then come back. I think that one's going to be for plea. So if we could, maybe we should talk to him first and come back and do that. And then that way we can get Carlos out of here.
Is that defendant the one in the county jail? Remind me his name.
Yes. His name is Jesus Gonzalez Fermin.
Okay.
And you need a breakout room, correct?
Yes, please.
Oh, you need a breakout room first. All right. I was ready to call
Just briefly, yes.
Okay, Carlos, could you tell the defendant to go in the breakout room with his attorney? And could you go with them?
All right. Señor Jesús, vamos a volver a hablar con el abogado en una sala de grupos pequeños.
All right, Judge. He seems to be frozen. Maybe he's gone. It's just us now.
Missy, on pay or appears, if we were going out 90 days, what would our 90-day time period be?
90 days would be November 20th.
Thank you.
Mm-hmm.
I like the judge's glasses matching her scarf. It's like the reverse version. Hold, please. Is anybody coming back?
I'll be here, Judge, whenever they're ready to proceed.
Okay, thank you.
Judge is just catching up on the news, I think. All right. It's all good. It's all good. See if we've got anybody else we can jump in on. Preferably live. Still looking, still looking. Got Judge Ramsey Heath is still going at it. What's this one? Hang on.
Thank you. Mr. Price, state your name for the record, please.
Cornell Price.
Thank you. I understand this 11 to 15 over, which would have been a 3-point ticket, is being amended to blockading traffic, a 0-point ticket that does not report out to insurance. Is that consistent with your understanding?
Blockading traffic?
And the other 2 counts will be dismissed? Is that consistent with your understanding?
Yeah.
Yeah.
Are you admitting that on July 27th of 2026 in the area of 94 and Van Dyke that you were exceeding the speed limit, which we are reducing to blockading traffic?
How does that even work?
I'm not admitting, no.
Okay, we'll proceed with the formal hearing. Please get the officer here. We will be going forward on the 11 to 15 over. No registration and no proof of insurance.
You just had a sweet deal and you just blew it.
Yes.
Yeah, this docket should not be running until noon. I need the officer here.
Okay, let me go and get, okay. And this is on Pittman?
He could have had
Right.
blockading, and now he's going to get nailed for 15 over.
Okay.
He's going to get points.
Can I give you just a little background? Because
The dude doesn't even know what's going on. You need to pay attention, talk to the lawyer, understand the process, and then answer appropriately. And you didn't, sir. You didn't. You had to admit that you were, in fact, blockading traffic to get that deal. When you decided not to, you're now going forward with the hearing. We're now in trial. And guess what? They're going to be able to prove that you were speeding. This judge hates her job. I feel it. He's like, I thought we'd be done by now. You know he's going to be confused at some point. It's like, I thought we were doing blockading. Maybe take your head covering off during court. Oh, we're looking at the poster board. Looks like the work schedule's up on the wall, and everybody has next week off. No, just kidding. Please let the officer show up. If the officer doesn't show up, this will work out for him. So instead of taking a blockading, he goes ahead and gets the whole thing dismissed. Yeah, she's in a terrible, terrible mood. I haven't watched a lot of her, but I think this is like her MO. This is her. She comes in with a bee under her bonnet. That's just how it goes. What are you guys' plans for the weekend, by the way? It is Friday. Do any of you have wonderful weekend getaways or get-togethers on the menu or on the docket? Yeah, Corey Richard's hearing doesn't start till 4 p.m. today. There's no officer that I can see.
All right, back on the record in the matter of People versus Cornell Price, P1938915. This is City versus Cornell Rice. Everyone's already placed their appearance on the record, except for our city attorney. Please go ahead from the city attorney's office.
Karen Riley on behalf of the city, P89298.
Thank you. Today is the date and time set for formal hearing and trial in this matter. Officer Turner did call in earlier today and let us know that he had not received notice, although we were sure he had been notified at the last court date, but he says he didn't get it. Did people have a response?
Your Honor, under the circumstances, the people are not opposed to dismissing this without prejudice and will move to reissue.
Okay, so he didn't win.
No objection, Your Honor.
All right, I'm going to go ahead and grant the dismissal without prejudice, Mr. Price. Without prejudice means it's being dismissed because the officer is not here. He's in another courtroom. Means they can refile it at a later date if they wish to do so. And then we would just start over. Okay, but as for now, tickets are dismissed. Have a good day.
Thank you, miss.
And she shuts off her live stream. She was frustrated that she had to do that. She's It's like he won. He won on that one, just a little bit. Let's see. Judge Webster's still doing that. Texas still at it. Let's see. When does we're about ready for Thurston to come on board? Do you think we can get like a foliage Friday going out of Thurston? Let's do a quick search there. Thurston County Courts. Not seeing it yet. They had a jury trial yesterday. Was it a good jury trial? It looks like they broke it into like 600 pieces. 48 minutes, 40 minutes, 3 minutes, 47 minutes, 12 minutes. Just going to ask about Foliage Friday. We are ready for some foliage. If you guys are aware of any court that has some foliage related events going on. Let's see. See what Judge Stevens is up to.
Restitution from the beginning, and the defendant has been on probation for over a decade.
Over a decade?
We're talking about 11 years now. And it's all about money, right? The restitution, where are we?
Since the last court proceeding, Your Honor, she'd only made one payment, and that was earlier this week in the amount of $1,002.
Okay. And when was the last time we were?
February 13th.
In February.
Yes.
Okay. So what is that? That's 6 months, a half a year.
Yes, it is.
You've had her on a rotating review in 6 months, Judge.
What is the balance on the restitution?
It's $20,435.26.
I'm sorry?
$20,435.26.
That's the balance.
Yes.
Well, it was 60,000 at one time, so it's whittled down to it. It's better than some folks. Okay, so, well, what happened here on the delay?
I didn't have access to online, and there's other things coming up. I'm not making excuses, but I did. You're Miss Lee. Okay, sorry. They changed that, so I didn't know. I did talk to her when I made that payment, and she did give me access to online, so I can start making the payments instead of having to drive to Beaumont to make them.
Okay, so are you going to do this in a monthly?
Yes, sir.
How much are we?
I'm going to try to get back for the original $650 that I had agreed to pay per.
Which was what?
650.
She agreed to that back in 24.
650, you said?
Yes.
Yeah. Well, that would be nice because that, that would end up getting this thing over with in 2.5 years.
It's been going for 10, what?
She's been averaging about 3,000 a year, just looking back roughly at my notes, Judge.
Mm-hmm.
It's a lot better than some, but not exactly where we need to be.
So, I mean, but again, we're still owing 8,000, right?
$20,435.
Okay, but she's at her rate, she can pay 8,000 a year at the rate. That's 800. It's
a lot to pay off.
Get back to that. Also, otherwise, the restitution about this hopefully all that will.
Okay, the audio is terrible. We're going to jump to Judge Elmore.
Triangle again. No solid lines are coming to me, but it is a solid line between you and the prosecutor. And that solid line has a word or a name. It's called Killebrew. Killebrew means that if I don't go along with that portion of the agreement, you would have the right to come back and withdraw that plea and come back to this stage of the proceeding. Meaning, if I gave you 12, or if I gave you 13 months in prison, then you could say, whoa, Judge, I want to withdraw my plea and negotiate this case again. Does that make sense?
Yes, Your Honor.
Has anyone promised you exactly what I would do at sentencing?
No, Your Honor.
I generally am fairly predictable, but I don't know because I haven't seen any reports. All right, now by entering a plea, before I go over this, have you gone over with Ms. Moss all of your rights, the evidence against you, your choices of going to trial, strategies, things like that?
Yes, Your Honor, I have.
And either her or I think Mr. Williams might have been assigned to it. Are you satisfied with their representation as of up to now?
Yes, I am, Your Honor.
All right. Now, if you enter a plea of guilty, you're not going to have a trial of any kind. Does that make sense, sir?
Yes, Your Honor.
I have a form here that's got, it says advice of rights, and it appears to have your signature. But I'm going to put this here in the file. I'm going to go over them with you verbally.
Okay.
Number one, if you enter a plea of guilty today, you'll be given up certain rights. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at trial, the right to remain silent during the trial, the right to not have a silence used against you, and the right to testify if you choose to testify. Mr. Hughes, do you understand those rights?
Yes, I do, Your Honor.
Even more importantly, do you understand that if you enter a plea of guilty today and I accept that plea, you'll be forever waiving those rights as they apply to this particular case?
Yes, I do, Your Honor.
Additionally, any appeal as to the conviction and sentence pursuant to this pretrial agreement would be by filing an application for leave to appeal, which is different than a claim of appeal by right, which is only guaranteed when someone's been convicted of a felony in a courtroom. Also, furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial, and you'll also be given up the right to claim that the plea was a result of any other promise, threat, or inducement not told me right now. Have there been any other pleas, promises, threats, or inducements to compel you to plead guilty that we haven't talked about?
No, Your Honor.
Has Miss Dollar, anyone come to you and threatened you with firearm or maybe a sharp pointy spear to make you plead guilty?
No, Your Honor.
All right, good, good. All right. You still assent to the plea?
Yes, Your Honor, I do.
That's to count one, operating a vehicle. Operating a vehicle while operating a vehicle while intoxicated is the third offense. How do you plead?
Guilty.
Now, before I can accept that plea, I'm going to ask you some questions. Explain to me what it is that you did that makes you guilty of the offense. Turn your attention to June 8th of 2026 here in Herring Township in Wexford County. Were you operating a vehicle on a road or public roadway, specifically, I think it's Cecil Road?
Yes, I was, Your Honor.
And when you were operating that vehicle, did you get stopped by law enforcement?
Yes, I did, Your Honor.
And before operating that vehicle, or I guess while, had you consumed some alcohol?
Your Honor, it was a controlled substance.
I got it. I just saw that. Everybody jumped on me. I got it though. Had you consumed some kind of controlled substance?
Yes, Your Honor.
And what was the controlled substance that you had consumed that was in your bloodstream?
Methamphetamines.
All right. And clearly you didn't have any lawful right to consume that methamphetamine, correct?
No, Your Honor.
And did it impact your ability to operate a vehicle, obviously enough that the officer stopped you?
Yes, Your Honor.
Now, Mr. Hughes, is it also true that previously you were convicted on January 20th of 2015 in this court for operating while intoxicated?
Yes, Your Honor.
Is it also true that on or about November 19th, 2020, in the 84th District Court here in this county, you were convicted of operating while intoxicated?
Yes, Your Honor.
All right, Ms. Dahl, has the defendant provided no, I already knew that. We already told me about the blood report. He already told me it was methamphetamine. All right, do you believe he's provided a factual basis enough to support the plea?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No.
Do you believe the court's compliance to court rule 6.302?
Yes.
Ms. Moss, do you agree with all those answers?
Yes.
Thank you. The court agrees and finds that the defendant's plea today has been made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant on the record satisfies the required elements of proof. Simply, the court finds that even the consumption of any degree of methamphetamine, especially what impairs the ability to operate a vehicle, satisfies the required elements of proof. Therefore, the defendant is found guilty of count 1. Count 2, and it's sentencing enhanced, the habitual felon in third will be dismissed at the time of sentencing. Mr. Hughes, sentencing will be in about 4, maybe 5 weeks coming from this, beyond this coming Monday. This court does sentences on Monday mornings. Between now and then, an agent from the Michigan Department of Corrections, also known as the Probation and Parole Office, must prepare a pre-sentence investigation report. One such report must be prepared anytime someone is convicted of a felony in a state court in Michigan. That report requires you to do 3 things. Number 1, you're going to get a packet at your home. You're going to complete it and turn it in. Number 2, you'll have an interview with an agent from that office. You have the right to have your attorney or one of your attorneys present during that interview. And number 3, once it's prepared, a copy of it's issued to your attorneys, and they will have to meet with you to go over it, because each attorney has the right, or each party has the right to come to this court and request corrections or make objections to the content, the scoring, and so forth. So it's important that you maintain communication with your attorney. Do you understand all that?
Yes, I do, Your Honor.
I don't think I've missed anything. The court, any objection to continuation of bond? I don't see any bond violations here.
No objection, Your Honor.
Bond hereby continues. Mr. Hughes, make sure that you attending or complying with all your bond conditions. And if you are getting any treatment, I strongly encourage you that you do so. If it are you in treatment right now?
No, I am not, Your Honor.
If you are able to get into a residential program, I generally have the tendency of delaying sentence and encouraging people to do an inpatient program, which is generally 30 days. And then if they have a sober living facility, which are generally 90 days,
okay.
I tend to adjourn sentencings out to allow the completion of that programming, because I want, when you come here to sentencing, you say, hey, Judge, I'm doing great. Everything's awesome.
Right.
And then, because if you've got a 9 to 23, how you've done on probation, parole, or whatever in the past, how you've done on bond in the past, and how you've done for treatment will really be a big impact. Right.
Thank you, Your Honor.
All right. Thank you all very much. Anything else, Ms. Moss?
Nothing further.
All right. Thank you. We're adjourned. Have a good day.
Bye-bye.
Thank you.
The last hearing for the day, Judge?
Please.
Yes. Call him.
Our next file of the day is People of the State of Michigan versus Drew McCollum. File number is 26-14327.
Sit down for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. McCollum. I know he's here. I just talked to him. He's making his way up to the table.
All right.
I'll be right back here.
All right. Thank you. All right. So we're here today for a pretrial conference. Looks like the attorneys have reached a resolution of the case for a plea.
We have
Mr. McCollum is currently in pretrial custody. He's been brought here to the courtroom. Mr. McCollum, are you anticipating entering the plea?
Yes, sir.
Please, to the best of your ability, raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, you may lower your hand. Mr. McCollum, because I like to extend a little bit of trivia, do you know why you raise your right hands?
No, why?
I don't know.
It comes from the tradition of that whenever you came upon people that were strangers 100 years ago, the best way to prove that you didn't have a weapon in your hand was to show your hands. your trivia. I didn't want you to leave the day at the end.
Thank you.
This, plus it also allowed Miss Dahl to get back here in the courtroom. All right, sir, you are currently charged on a felony information with a felony offense. Now, looking back on July 29th of this year, just a month ago, were you on probation, parole, or bond anywhere?
I was on probation.
Has there been a probation violation filed?
Yes.
Has it been resolved?
No.
Anything you say today can be used against you in that probation violation. Do you understand?
Yes, Your Honor.
And whatever sentence you would get, because it's not a violation of parole, would most likely run concurrent with one another. So if I gave you, and I don't know what I'm going to give you, but I'm just going to use some round numbers. If I gave you 100 days and the other court gave you 100 days, they would run together or overlap, okay?
Yes, Your Honor.
All right, that's good. Now, you were charged on this felony information with a single count of 2 counts. 1 count of retail fraud in the first degree. Now, retail frauds come in a couple different varieties, 1, 2, and 3. Some are misdemeanors, like a retail fraud third is a misdemeanor punishable after 90 days. And a retail fraud second is punishable by up to a year. What this tells me is that based upon you having some priors here, you've got a retail fraud in the first degree. Now that means it's a felony punishable by up to 5 years and or $10,000 or 3 times the value of the property stolen, whichever is greater. Now there's also a 4th habitual felony offender enhancement included here, which would, within the discretion of the court, allow the court to increase that potential punishment from up to 5 years to up to life. But if you plead guilty to count 1, the prosecutor agrees to get rid of that 4th habitual enhancement, meaning it will still just be a felony punishable by up to 5 years and or $10,000. Do you understand?
Yes, Your Honor.
Also, count 2 says you assaulted, resisted, or obstructed a police officer, which is a felony punishable by up to 2 years and or $2,000. And because of the 4th habitual felony offender enhancement, it could, at the time of sentencing, allow the court to increase the potential punishment from up to 2 years to up to 15. However, that count and its enhancements will be dismissed. Is that what you understood?
Yes, Your Honor.
Now, before entering into this pretrial agreement, have you gone over the evidence, your rights, your tactics, your choices of trial, things like that with Mr. Harrison?
Yes, Your Honor.
Now, I have this pretrial agreement. I'm holding it up. Is that your signature on page 2?
Yes, Your Honor.
Before you put your signature on it, before you came in here to talk about this plea, again, Mr. Harrison, he's made himself available.
Yes, Your Honor.
All right. Are you satisfied with his representation?
Yes, Your Honor.
Thank you. Ms. Dahl, did I get the terms of the agreement correct?
I believe so, Your Honor.
Thank you. Mr. Harrison?
It directly comports with my understanding, yes, Your Honor.
Now, there's another thing on this pretrial agreement at the bottom. It says, estimate sentence guidelines.
Welcome, Larry.
9 to 23 months. The sentencing guidelines are given to us by the legislature to help courts establish a fair and reasonable sentence, or at least based upon how the legislature sees it. We are, as judges, are not required to follow them. We must consider them, but they are not mandatory. They are advisory. I need you to know that even though it says 9 to 23, that doesn't mean I have to follow it. Do I normally? Most of the time. Also, it says 9 to 23, but before it said the word estimate. We don't know exactly what the guidelines are going to score. We'll know before we do the sentence, but when the attorneys are generally pretty good at doing them, but we don't know exactly what they are. Do you understand that?
Yes, Your Honor.
All right. Has anyone led you to believe exactly or told you exactly what I will do for sentencing?
No, Your Honor.
Good, because I do not know. Now, by entering the plea of guilty today, you're not going to have a trial. Does that make sense, sir?
Yes, Your Honor.
This next page I'm holding up says at the top, advice of rights, and the bottom appears to have your signature. Once again, is that your signature?
Yes, Your Honor.
Are you a doctor or a lawyer? Because that is a really bad signature.
I'm an artist.
He is wearing handcuffs.
All right. Well, anyways, before you place your signature on this page, did you read all the information and rights above it?
Yes, Your Honor.
Did you understand the words and the rights that are there?
Yes, Your Honor.
And you understand that if you enter a plea of guilty today, and I accept that plea, you're going to be forever waiving these rights that applies to this particular case.
Yes, Your Honor.
You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me right now.
Yes, Your Honor.
Have there been any other promises, threats, or inducements?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, I'm going to get ready to take the plea here, and I want to make sure I did everything right. I got your rights. I covered the charges, the plea, All right, good. And the guidelines. So are you ready to plead guilty?
Yes, Your Honor.
As to count one, retail fraud in the first degree, how do you plead?
Guilty.
Before the court can accept that plea, I need to ask you some questions and have you tell me what it is that you did that makes you guilty of that offense. Turn your attention to July 29th of this year out in Herring Township here in Wexford County. Must have been the Walmart. It is.
It's Walmart.
What is it that you did?
Always Walmart.
I walked out with goods that I didn't pay for.
All right. Now, did those goods have a price added together that was for $200 or more, but less than $1,000?
Yeah, I believe so.
Okay, what'd you take?
It was some electronics,
In front of the Walmart.
camping gear, backpack,
Mhm.
couple pairs of shorts or something.
Okay.
Just
Did you
grab
take
whatever
any
you
TVs?
No TVs.
We once had a case here a couple years ago where a guy took a TV, it was one of those big flat screens, and he walked out the door, and then his shorts fell down.
No,
It was really quite funny. That wasn't you, was it?
no, definitely
No
not.
surveillance video then.
All right. All right, so let's take a look here. I need to ask. It looks like back on January 8th of 2019 in the Sixth Circuit Court down in Oakland County, you were also convicted of retail fraud in the first degree. Is that correct?
Yes, Your Honor.
Okay. All right. And did you actually make it outside of the doors?
Yes, Your Honor.
Good enough. Thank you. Ms. Dahl, we believe you provided a factual basis.
Yes.
Are you aware of any of the promises for inducement? No. First question is supposed to 6.302. And we're right up to noon. Mr. Harrison, do you agree?
Yes, no, yes.
Copy. All right, the court agrees to five defendants pleaded. They is made freely, knowingly, and voluntarily. Court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof. Therefore, he's found guilty of count one. Count two, and the enhancements will be dismissed at the time of sentencing. Mr. McCollum, we will be back here in about 5 weeks. We do sentencing here on Monday mornings. Between now and then, an agent from the Department of Corrections, or also known as the Probation and Parole Office, must prepare a pre-sentence investigation report. One such report must be prepared anytime someone is convicted of a felony in a state court of Michigan. It will describe the agreement, our convictions, prior performances of bond, parole, or bond. It will include a scoring of the guidelines. It will also include a recommendation. Please again keep in mind that those guidelines and recommendations are only advisory. Step number one, for you to help prepare this report, you're going to get a packet. It's already been provided to the bailiff. He's going to give it to you. You're going to complete it and turn it back in. Number two, you're going to be subject to an interview with an agent in that office. You have the right to have Mr. Harrison present there. And number three, prior to coming back to court, each party will receive this report. Then Mr. Harrison is going to come and meet with you and go over it. Each of the parties has the right to come to this court and request corrections or make objections to the content and scoring. You understand?
Yes, Your Honor.
Any questions about what we have done today, Mr. McCullough?
No, Your Honor.
All right. Mr. Harrison, anything further?
Nothing further, Your Honor. Thank you.
The court revokes bond, remands him into custody. Anything further, Ms. Dahl? Thank you very much. We'll see you in about 5 weeks, sir.
All right, thank you.
Have a good day.
Don't take stuff from Walmart anymore. They'll get you. They'll get you. They don't play around. All right. A couple little courts. Let's see if we have...
In front of the Walmart.
Not seeing Judge Boyd today. Or Judge Dad. Ooh, here we go.
November 30th. Pay it at any DivDad kiosk in the city of Detroit. I'm told you can upload the DivDad app to your phone or come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it. There are other ways online and things like that, but those are just the two best ways. If it's nothing further, sir, I wish you the best of luck. Congratulations on your senior year. And we wish you the best of luck in that and your future endeavors, all right?
Don't get caught
Thank
anymore.
you. You guys have a good one.
You have a better one.
Good day, sir.
You have a better one.
Mr. Dillard, do you want to arrange or try to get Miss Tiffany Long? She's here early. She's supposed to be here at 1:30. You have to go somewhere?
Sir, no, I'm on the clock to work, so whatever you need.
All right, City of Detroit versus Tiffany Long. Case number SP 1942391, counts 1 and counts 2. Appearance for the record, please.
Joseph Dillard on behalf of Tiffany Long.
Miss Long, good morning to you. State your name for the record, please.
Good morning, Tiffany Long.
You at work, ma'am?
Yes, I'm going into an area right now.
You're getting service, aren't you? You're getting service. You can tell them Judge Perkins gives the best service out there. Miss Long, you're here a little early, but we're gonna. Mr. Dillard is willing to look into this. There's a no ops, Mr. Dillard, a no insurance proof civil infraction, and an expired plate civil infraction. You can run Miss Long's license, Miss Schmidt. Miss Dillard, Miss Long, I'm going to put you in the breakout room with Mr. Dillard. He's going to attempt to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Okay, thank you.
Join the room. We'll pass the matter.
And
thank you for your patience, Your Honor. I will be in here the rest of the docket. Mr. Dillard, I'll meet you in 4 when you're ready.
Okay. Again, there's no ops.
No insurance proof, 2 civil infractions, a no insurance proof,
no
and
proof.
Expired plates.
And her license is expired.
Very well.
Yeah, she's gonna get
Okay,
stuck
so
with something
license
there.
expired. No ops. No proof of insurance. So it's 3 or 4.
So it's 3. So she just ran Miss Dillard, Miss Smith just ran the license, and it reads that it's expired. She has a no ops, a no insurance proof civil infraction, and an expired plate civil infraction. 3 cases.
Okay.
All right. Let's pass the matter.
What day was she? Is she here today?
This afternoon. She's supposed to be on the afternoon docket. She came in early.
Okay.
Hello. Hello. Oh, they hung up. Sorry about that. Thought we had a call.
What happened?
Miss Lewis, are you there?
In Nevada right now, we weren't planning on covering this with its own standalone video, but in Nevada right now, today they're going to be dealing with the jury instructions. A little bit of lawyer only, just judge and the lawyer. Keefedy will not be present today, but we're just waiting for that to start down there. I imagine it will be probably a short day, and then we won't be back with closing arguments until Monday on that one. So keeping an eye on that. I'll bring you that. We get to watch how that goes down. But
Sending a court order saying that I can get my firearm released from the 9th precinct.
I don't know anything about that. I don't know why they would have taken your firearm. I have no clue, and I have nothing in front of me
stating that I had a firearm at the time of the incident. Exactly. That's what they missed, and that's the thing. I don't know. She said they weren't charging me for CPL, CCW because I have training and classes and certificates for my firearm.
All right. Well, Miss Bradfield, this is a dismissal for valid documents.
Yes, Your Honor. It's a little more detailed than that, but yes, Your Honor, that's what the dismissal is for.
I'll just say per city attorney.
Okay, thank you.
All right. I don't know about the firearm or anything like that. If
You're
I'm
an OG.
presented with an order or a motion, I can review it. All right.
Okay, how would I go about doing that, Your Honor? Because they said I would need.
You may need to hire yourself a lawyer.
Okay, I really appreciate that, Your Honor. So this case.
I wish you the best of luck, Miss Lewis. Have a very good rest of your day. Okay.
Thank you.
All right. What is this, Shantanique who?
Shantanique
Grant, she just called on the phone. She was scheduled for 8:35.
Why are you so late, ma'am?
Because I got my time mixed up. I thought it was at 11:30, and I just found the card. It was at 8:30 this morning.
This is the city of Detroit, Miss Bradfield versus Shantanique Grant, case number SP 1934917, counts 1 and counts 2. Appearance for the record, please.
I know it's muted. Daphne Bradfield on behalf of Miss Grant. State your name for the record, please.
Chantinique Grant.
All right. Well, good morning to you, ma'am.
Good morning.
Today is the date and time, and it's set for a
The judge is off wandering around.
Pre-trial, Your Honor.
Pre-trial. I'm trying to get this printer. All right. Ms. Bradfield, give Ms. Grant an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, Ms. Grant. Join the room. You let us know what you want to do when you come out, please.
I think the state of Michigan seal that's behind him would look really good as a challenge coin. Just like a nice metallic. That's a good coin. What would you put on the back of it? What would be on the back of it? Maybe a map of the state? If you see a deer standing up like our state seal, run, says JMR. Yeah, that means they're going to pummel you with their hoofs.
Monster bid.
Judge, what are you watching? No, you're not muted. What were you watching with a monster bid? I'm curious. Anyone recognize that little audio soundbite? Fountain of Youth pen. Yes, I am. I'm still interested in doing a challenge coin. The problem is, it costs $2,500 to $3,000 to make them, and I know I could recoup that in selling them. I just have to front it on the front end. So, and then settling on a design I'm happy with is also a challenge for me. I struggle with choices. Mega Braden covered the verdict in LC. We're not going to live stream it, no. I saw yesterday a whole bunch of people had their live streams taken down from the LC closings for YouTube terms of service violations, which is a tough one. It's not a copyright issue. That's YouTube saying we don't want this content on our platform, and that can get you banned as well. People were mass reporting. I don't know. That was not a glitch. That was the system working the way YouTube designed it. Yeah. I've had a few jobs.
Madam Clerk,
Yes, sir.
are you able to do an SOS check on Tiffany Long, 130 arraignment hearing?
I already did that. She's expired.
Okay, thank you very much.
You're welcome.
She has expired. Our condolences. I think they're talking about driver's licenses, though.
record. On record in State versus Davis, C-377-407. For the record, Mr. Davis has waived his appearance for this hearing previously. What document are we working off of, Mr. DiGiacomo?
The one I just sent you.
Okay.
We negotiated some language in a bunch of the instructions.
Okay.
The issue still before the court, and I sent, you got the defense instructions earlier.
Yes.
Is one, whether or not we give a voluntariness, and if we give a voluntariness of the statement, what voluntariness of the statement instruction should be given.
Okay.
Two, we have a dispute over what corpus delicti rule instruction we give.
Of course.
The defense has withdrawn their 51069 request. The attacking the hearsay as if he testified to the client, as if he testified, they've withdrawn that.
Okay.
And then the defense does not want self-defense instructions, but the state believes we're entitled to them since Mr. Davis claimed self-defense in at least one of his statements.
Okay, this is live out of Vegas. This is just jury instruction.
Good morning, Your Honor. Attorney Talene Panduck, bar number 5734, on behalf of the defense.
Ooh, first time we get to hear from her.
I did print a copy
sort
of
directly.
our initial defense proposed instructions. Would you like a printed copy for now?
I have an email copy if you want those filed. Go ahead and.
Well,
as
we
proposed.
we are withdrawing one of the instructions.
Okay.
On page 9. On page 6, we're withdrawing the hearsay instruction. Pages 7, 8, and 9, the state has agreed to modify those and use our proposed exhibit.
Okay.
So you are here to determine if the defendant is guilty or not guilty based on the evidence in this case as opposed to guilt or innocence.
Okay.
And then the state also changed the one about the subject of punishment to not say guilt or innocence, but to talk about the burden of proof. The state has also agreed to give the instruction on page 9 of our proposed instructions on the constitutional right of a defendant not to testify.
All right. So then what I think makes the most sense, tell me if I'm wrong, is just to go through individually. When there's no objection, just number that, move on to the next one, and organically raise the issues as they come up with the instructions. If there's something that doesn't get raised, ultimately by the end, then I'll circle back and ask about the defense proposed.
I would agree with that, except for I don't think you want to number, if you do wind up giving the voluntariness, I don't think you want to number them after the last instruction. So
you want to start with
maybe we should address
voluntariness?
whether or not we should be giving voluntariness, and then when we get to the area where you want to argue voluntariness.
All right. Let's go voluntariness of statement as our first issue. Let me pull up the instruction that you have proposed. Defense.
Is there a pattern instruction, or are we just going with defense and prosecution proposals?
And then state has presented an alternate.
An alternate, but also an argument that there is no voluntariness that gets submitted to the jury.
Okay. So is the instruction that you are proposing to give the one from Vasquez-Reyes versus State and Colorado versus Connolly misconduct?
No, I am.
That's the one that the state is proposing.
My proposed is from Carlson versus State, 84 Nevada 534.
If you actually just want to approach with yours, at this point, I don't know. It doesn't look like I received your entire packet, so everything. So I can just go through it printed. Thank you. All right. So the instruction that the defense is proposing three different instructions, correct?
I have 3 different options. The first one is directly from Carlson versus State. The second 2 are from instructions that I used as a district attorney.
All right. So what's your preferred one that I start with?
You have to choose.
I'm happy with all 3 of them.
Okay, so you'll take any of the first 3. So either
State.
And definitely the second one on page 3 talks about the difference between an admission or a confession. So that one's different from the page 4 one, which talks about the totality of the circumstances and the voluntariness.
You got to pick one. The judge isn't going to
State,
choose
what's your
for you.
objection regarding a voluntariness instruction being given at all?
In both the cases cited by the defense, and I recognize, both of them say where voluntariness of a statement is an issue, that you have to submit it to the jury. The mere fact that they filed a motion to suppress on voluntariness doesn't create an issue. They have presented, you have to, as Connolly says and Vasquez-Diaz says, you have to establish some improper police coercion, and they have not done that in this case. The audio of the statements do not reflect any improper police coercion. Both of those, neither one of those, have you found to be to be custodial, and so in both these cases, they're Mirandized statements of defendants who are in custody. There is a lot of law that, right, if there's evidence of self-defense, you got to give self-defense. If there's evidence of a voluntariness, you have to give a voluntariness, voluntary manslaughter. There is zero evidence before this jury that they could factually make any sort of determination as to the voluntariness of the defendant's statements. By its very definition, a proffer cannot be involuntary because it is a negotiated contract between two people. So the only statement this could apply to would be the 2009 statement. And when you listen to the 2009 statement, it's clear there's not a single improper coercive conduct by Detective Long. Now, had the defendant got on the stand and said, hey, they beat me with rubber hoses before I went in the room, or hey, the cops told me this, or the cops told me that, or the cops told me this. The evidence before this jury is he was caught with PCP and a gallon of PCP and a kilo of cocaine. They told me I could be prosecuted for that, or I could give a statement. I negotiated a contract with my lawyer, with the government, to go in and give them a statement. By its very definition, it cannot be involuntary. And so, if you instruct a jury on this, particularly the instructions they're requesting, it would be highly, highly confusing to the jury, and it's not an issue in the trial, because they've brought zero evidence of coercion, improper police coercion, into this case. And because of that, I would say they're not entitled to a voluntariness instruction.
In reviewing the instructions that are proffered, Ms. Pendick?
Can I approach to give you the two cases, Carlson and Morrison?
You may. My initial concern in reviewing what you have stated, before I even get to the threshold matter of whether you've met, well, first I'd have to decide the threshold matter, but if we were to give an instruction, all instructions say that ultimately if a jury concludes that a confession or admission was not made voluntarily, then it's up to the jury to determine whether they should consider it. However, none of the three instructions give any insight to the jury as to how they would determine voluntariness. As a judge, when there's this motion to suppress brought up before me, in general, I have factors to consider. The jury would have none of those in the proposed instructions, and so it would be giving them a task that they have no way of accomplishing, essentially, is what is in front of me.
And what the defense is submitting in the Carlson case, they had an instruction that the Nevada Supreme Court ruled was sufficient in that case, and that is in the state's first proposed exhibit. And they actually gave the footnoted instruction of the fact that the court has admitted into evidence the alleged confession or admission of a defendant does not bind the jury to accept the court's conclusion, and the jury, before it may take a confession or admission into consideration, must for itself find whether or not it was voluntary confession or admission. If the jury concludes that a confession or admission was not made voluntarily, it is the duty of the jury to entirely disregard the same and not consider it for any purpose. That is directly from the Carlson case.
They're saying voluntary carries a clear meaning without need for further definition or explanation.
That was going to be my very next argument, Your Honor. And they did say that it was error if the court did not give that instruction. And what they talked about was, and this is going to be something that's a theme running through all of our objections, there is a difference between admissibility and the question of fact that the jury now needs to decide. So here, Mr. DiGiacomo is absolutely correct that you have the initial determination of admissibility. You have ruled that it was voluntary. This will be an issue on appeal. This will be something that will be brought up by the defense should Mr. Davis get convicted. However, you also then are required by the Nevada Supreme Court to instruct the jury based upon their role now, which is determining whether or not there is evidence beyond a reasonable doubt. To me, that is how I read these Nevada Supreme Court cases, that you need to give these instructions. I do see the court and Mr. DiGiacomo's concerns. It is the defense position that we'd rather have all of the instructions given as opposed to just the state's. So I think it's better to instruct the jury than to not about all of the applicable rules. But I do think, and this will become even more important in the next argument about corpus delicti, I think that we do not need to instruct the jury on questions of admissibility. I do not want them to be confused about the proper standard that they need to decide, which is proof beyond a reasonable doubt. At this stage, it's a question of fact for the jury.
So let's work backwards then. Where in this record do we have evidence of improper police coercion, where we don't have, we have a statement that was given in the presence of police, or in the presence of his attorney that he brought there. We don't have any of the typical PASAMA factors present of, someone who's very young, someone who's very hungry, someone who's very tired, someone who's very susceptible to police coercion because of their lack of familiarity with the criminal justice system. We have none of those factors present here. Additionally, we have a defendant.
Would disagree.
But hang on a minute, and we also have someone who has not testified to explain a circumstance outside of those. Outside of what is actually within the videos, and then ultimately no evidence that apparently it would be difficult to know what to apply to this situation. But what is the, improper police coercion here?
Well, the defense, we all should not be arguing this right now. It's a question of fact for the jury. I'm not going to restate the evidence that we already heard at the trial because it's up to the jury to decide.
You need to make a prima facie case.
Exactly, but it is our position that those factors, whether they've been met or not, would be up to the jury to determine. Both sides are going to have arguments and closing arguments that are going to be very different. This is one of the biggest issues in this case, and I think it's important to continue on to allow these instructions to be given as decided by the Supreme Court. I think it would be error not to give the instructions, and I think that there is some evidence of psychological pressure. That is going to be something that the defense may argue in this case based on the testimony at trial, but I don't think it's appropriate for us because it's a question of fact for the jury.
But we need to get at least that there's something in the record to show, like if we're talking about voluntary manslaughter, you have to have at least that scintilla of evidence to get over that very small molehill. What evidence is there to give these voluntariness instructions at all to get that first hurdle that Mr. DiGiacomo is, complaining about?
And I know that this court disagreed with the defense when it filed its motion to suppress the statements, but the defense detailed at length what the promises were. There were explicit promises made to the defendant in the 2008 proffer. There were implicit promises not to use it against him in the second 2009 interview. And those promises, while contested by the state and contested by the court, there was evidence of promises made to the defendant. There was evidence about confidentiality that they agreed to keep. There was evidence about when that confidentiality was broken, who broke it first. These are all issues that are going to come up during closing arguments, and I'm sure they're going to be issues that are going to be deliberated by this jury in making a decision.
This lady's on
None
the
of that goes to voluntariness.
defense team.
Somebody violating something 5 years or 3 years afterwards doesn't change the voluntary nature of this statement. The person or the entities that contracted have never violated the agreement that was contracted. The contract was between Mr. Higgins and the U.S. government. The U.S. government never violated the contract. The suggestion that as a matter of law, you can never have an involuntary proffer. There would have to be some additional information that is elicited. The fact that they don't like what Mr. Kading did does not somehow change the nature of what happened 3 years before. And so the psychological pressures that they're talking about are exactly what U.S. Colorado v. Connolly say are not appropriate for purposes of the Sixth Amendment involuntariness. That is clearly not a situation where they're allowed to argue to a jury that because him and his family were wrapped up in a drug deal, that he somehow has the right to claim that his statements are involuntary. The Sixth Amendment is there to protect against improper police conduct. It is not there for this purpose. So when they use the term voluntary, he didn't have a choice. Well, he did have a choice. He could go to prison for the rest of his life on drugs. But he chose to make a statement to the police. And so there is no evidence of anything improper police conduct that has occurred here.
May I add something, Your Honor?
You may.
I wanted to clarify that the burden of proof is on the state to prove by a preponderance of the evidence that the confessions were voluntary. That is a burden of proof at the time of trial, not at the time of the motions. So in this case, they do have that burden to prove that beyond a preponderance of the evidence. So I think that's also relevant, and I think it's important in this case that we give this question to the jury based on the Supreme Court law that's in place. But as Your Honor well knows from all of the briefing in this case, there is very little law specifically on point to this issue. This is a unique issue. This is something that could create new law in the state of Nevada because there's very little law in Nevada that even remotely talks about the situation that we have in this case. And I think that it's very important to protect the record that the instructions be given. And I'll submit it to Your Honor.
Okay. I think it's safest to give some sort of voluntariness instruction to this jury. Given the precedent in the Nevada Supreme Court, given the Carlson versus State case, I definitely agree with a lot of the state's arguments, and that's why I ruled the way that I did initially. However, it's clear that this has been an issue that has been raised by defense. It's something that they disagree with my ruling with pretty strenuously. And in the record, there is, that statement by Detective Kading in that 2008 interview that this will never be used or this will never be heard, which was the basis for that voluntariness. I still think that wasn't the correct framework, but I think giving it ultimately to the jury is maybe a way to hedge our bets. So, that being said,
hedge our bets.
Let's talk about the various instructions and how we're going to do this.
I would ask the court, and I will tell the court that, I cannot believe I'm actually going to say this, but I pulled those instructions on voluntariness from the Nevada pattern jury instructions. The only thing I did was conform slightly to this case and added the Colorado v. Connolly portion that says self-interest or an expectation of receiving a benefit does not make a statement involuntary. That isn't actually in the pattern instructions, but clearly it's the law, and that's why I sent you Vasquez Reyes, because Nevada has adopted Colorado v. Connolly. And so the instructions I gave you on voluntariness, and I'm trying to pull them up here because I didn't have them up on my computer initially here.
And so these are, your instruction is the pattern?
Is the pattern with the exception of the last line on the first page.
Okay.
I believe.
And so, Ms. Pondick, the instructions that you've given me, obviously the one on page 2 involves Carlson and Lorson.
Yes.
Those are Nevada Supreme Court cases. The other 2 sites are simply for the stock CCDA brief bank instruction. Do you know where those necessarily come from, and if they were not incorporated into ultimately kind of the pattern? The idea was to incorporate those stocks into the patterns.
Those have been instructions that have historically been used by the district attorney's office that have been upheld by the Supreme Court. So those have not been challenged. Those haven't been, there have been no problems associated with those instructions. That was initially what I had asked the state to include that precipitated all of this.
Okay.
So I wanted to make sure that the court had those instructions. I agree with the state that their instructions are a correct statement of part of the law that applies. I'm not saying it's complete in terms of all the issues in this case, but as to the PASAMA factors, those are the factors, and I do agree that they're correct statements of the law. So we do not object to the admission of all the instructions, both the state's proposed as well as the defense proposed.
Well, the second 2 DA brief bank, I'll be honest with you, and then, you know, she was at appellate for a long time. Those are no longer in our stock instructions. These pattern instructions of what we've put into our stock instructions, because those are clearly, as the court noted, not adequate to explain to the jury voluntariness in a legal sense what that is. And so if you're going to give the instructions, I would urge you to give the Nevada pattern instructions with the Connolly addition to them. But not, well, I mean, I think it's superfluous to even have the what is it, the Carlson-Larson one, because these fully explain, these 2 instructions fully explain, hey, there's a confession and an admission, here's what the difference between the 2 are, here are the factors to consider in determining voluntariness, there needs to be improper police coercion involved in them.
I don't believe those 2 are sufficient. And I think that under Carlson, them saying that the term voluntary contains a clear meaning without need for further definition or explanation, that's also a clear mandate by the Supreme Court. But I would ask at a minimum.
Mandate from 1968.
Right. But there's been nothing.
In which the defense was actually asking to give the factors to the jury, and the court said it was sufficient in 1968. But this is a very specific voluntary issue, right?
Okay. Turning back to Ms. Pondick, when I look at the instruction the state is offering, it does seem to incorporate what you've included for 3. It talks about what an admission is, what a confession is, and what the definitions are. It seems to be very similar language, and I think it was probably what was used to make the stock pattern, the stock instructions that the Supreme Court is encouraging us to use.
Yes.
And so it seems to be the predecessor to that. Would you agree with that?
Yes, it is fine to use both of those instructions.
Well, I'm just saying, I don't know that we need instruction 3 if that one is being given.
That's fine, Your Honor.
Okay?
I just want to make a complete record.
No, I understand. I'm just, if you agree with me that it's already incorporated in the instruction, I'm not going to give duplicates. Okay. So
exactly.
3 doesn't seem to make sense. Page 3 doesn't seem to make sense. Page 4, let me compare that. I think page 4 does include additional factors, which include that the state has the burden of proving voluntariness by preponderance, but then it goes into the voluntariness being a question of fact to be determined by the and what you're to do if it is determined to be involuntary.
And I would ask that that instruction be given.
So I think 4 is incorporating your instruction 2. It has all the same features. So my thought is to give the state's instruction as well as page 4. And I'll let Mr. DiGiacomo be heard on that, just because it will avoid duplication of the exact same issues that could confuse the jury. Additionally, it includes an explanation to the jury of what to do to determine if it's when you determine it's voluntary or involuntary and who has the burden.
Okay, so you're going to give both of the states and then you're going to add 4?
Oh, the state has a second?
Yeah, the second
I haven't gotten to the second.
Yeah, the second one actually has all the factors listed out, and it does cover everything that's in her number 4.
Okay. Let me look at that one. I apologize.
Page 2 of ours, the PASMA factors.
The state, and it includes that the state has the burden of proving, which I indicated earlier was a very important part of instruction 4. I think ultimately in comparing page 2, it does encompass all of the ideas of page 4.
So instruction number 2 will not be given on page 2.
Right. I think what she's saying is she's going to take R2, it encompasses all 3 of yours. Is that what you're saying?
No, she's going to give on page 4.
Well, I didn't realize there was a page 2 to the state. What does the state's proposed either omit? I see that it adds the PASMA factors, and you guys don't want the PASMA factors given. Is that sort of the difference there?
I already said it was fine to give all 5 instructions, so I'm not saying that their proposed instructions are an inaccurate statement of the law.
Got it. Understood. So at this point, I'm going to give voluntariness instructions over the state's objection. However, I'm going to use the 2 that the state has proposed because they are pattern instructions, which we are encouraged to use. Additionally, in reviewing them and comparing them to the ones that were sent over by the state or by the defense, they do include all of the factors, as well as the fact that the state has the burden of proving the voluntariness by preponderance of the evidence. So I think they encompass everything that is necessary. They encompass the defenses, and to avoid confusion, I'm not going to give all 5. I'm just going to give the 2 that include the same ideas.
What about the one on page 4? You had said earlier you were going to give that one.
And I think that was before I knew that the state had given me even a second page.
Oh, okay.
So I was just looking at page
Okay.
1. I apologize. So now that I've got that. All right. So the voluntariness instructions will be given as proposed by the state, but to be clear, the state does not want voluntariness instructions. The other issue that we needed to address was corpus delicti. The defense is proposing on page 5.
And to be clear, Your Honor, the defense objects to the corpus delicti instruction proposed by the state. The only reason that we provided an alternative proposed instruction is because they included it in their packet. The defense objects to any corpus delicti instruction being given to this jury at all for these reasons. While the first attorney in this case had potentially raised a corpus delicti issue in his motion to dismiss, this defense team has not raised corpus delicti either in a motion or in front of this jury. That issue has not come up. It is a question of admissibility, not a question as to weight, and the defense objects to this instruction being given because we believe that it is confusing and misleading to the jury because their duty is beyond a reasonable doubt, and Their duty is as to weight, and it's confusing to even have this instruction. However, if the court disagrees with the defense position and will give an instruction, the case provided by the state, Sefton, that's actually from 1956, and the proper standard is the Doyle case. In the Doyle case, they provided, this is the exact instruction that comes out of Doyle, which is Doyle versus State, 112 Nevada 879 from 1996, Nevada Supreme Court, and that instruction is a more accurate statement of the law.
Your Honor, may I be heard?
Which one is your corpus instruction?
That is on page 5.
No, sorry, states. I'm on yours.
Okay.
It's near the end.
Give me the first couple words once you find it so I can...
Where independent evidence.
Where independent evidence. Okay, then I can control that then.
It's about 42 of 53. Although I may have I just added in the voluntary instruction, so maybe not.
So the instruction the state is proffering reads, where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I don't know that that's necessarily a corpus issue.
It is, Your Honor. So this is what, and I'm going to disagree with Ms. Panduck with regards to the defendant's the never taking the position that about the corpus delicti issue. What Mr. Saft told the jury in his opening statement is, you have to corroborate what the defendant says. That is not the law. So the question is, when we talk about what's clarity to the jury, what is the law? The law is we have to prove when a person gives a confession, absent their confession, we have to prove, one, that a person is killed, two, by the criminal agency of another. But what Sefton says, and what even Ms. Panduck's case says, and I'll get to why that's not applicable here, but what even Ms. Panduck's case says is that once you've established there's a crime occurred, you don't have to corroborate any other aspect of a defendant's statement. Now, of course, they can give it to whatever weight they want. But
Isn't that the inverse, though, of what a corpus argument would be? Is that there is only a statement and nothing to back it up. Yeah. You're kind of inverting it.
No, this came up specifically in Sefton. In Sefton, specifically what happened was there was a dead body, the person confessed to the crime, and what the defendant argued is, well, you never independently corroborated my other statements connecting me to the crime, therefore it's a corpus issue. And what the Nevada Supreme Court held is that there's not a third prong to corroboration. There's one, death, two, by criminal agency, three, what the defense had proposed, and what Mr. Saft has proposed to this jury specifically is that the third thing you have to do is corroborate that a defendant's statements connecting himself to that crime are true. And I don't think there's any credible argument to say that that's not what Mr. Saft said. I mean, it's a direct quote from his opening statement. But that's not the state of the law. And what Mr. Saft makes a argument that is an inaccurate aspect of the law, increasing our burden, we are entitled to an accurate statement of the law. And what an accurate statement of the law is that we do not have to corroborate anything beyond the corpus delicti. That is the corpus delicti rule, is that we don't have to corroborate anything beyond that. And so, the question for this court is Mr. Saft, because he's certainly going to say it during his closing argument, and he said in the opening statement, is Mr. Saft allowed to give a false impression about the law to the jury? And the question of that should absolutely be no. Because in the absence of anything, with the absence of an instruction telling them that we don't, that the corpus delicti rule is that we don't have to, and even if you don't want to call it the corpus delicti rule, the rule is, regarding confessions, is that we do not have to corroborate anything beyond person being killed and the criminal agency. And so Ms. Panduck, again, in Doyle v. State, the thing that she pulls is from a kidnapping case. from a kidnapping charge. But in another case that Ms. Panduck cites, West v. State, gives a very similar understanding of
You actually cite West v. State too.
Yes, well, she cited it, we cited it, we both cited it.
Yeah.
And the one thing that we can agree is the two parts of corpus delicti, the only thing that we have to independently establish is the death and by criminal agency. That's the only thing we have to establish. We don't have to corroborate anything else. And so the only question is the jury going to have to be, is the jury going to be misled about whether we have to corroborate or not? And what the instructions are there to do is to have them not misled as to what our burden is.
May the defense respond.
1 second. I'm not quite through with understanding the state's argument. Sefton states that you need, for a homicide, you need proof of corpus delicti, which we've always had in this case, right? No one ever...
Never challenged that. Well, not during the trial.
There have been challenges to which, in the media as to whether Mr. Shakur is alive or dead, but in general, we've always had the fact that Mr. Shakur died that day, and the body of the crime has always existed. And so corpus delicti wasn't really the issue here. It was the defendant's corroborating confession. Is that enough? And so...
Okay, so we can...
So I think that's...
So if you want to get rid of the first sentence where independent evidence established that the victim's death was caused by criminal agency and other, that's fine. But a defendant's own statements admitting the crime need not be further corroborated as an accurate statement of law. And if I may read from Sefton v. State, it does say, a conviction based on confession will stand, although it is uncorroborated otherwise by proof of corpus delicti. So what Sefton specifically says is, we do not need to corroborate a defendant's statement. What Mr. Sanft told the jury is we need to corroborate a defendant's statement. So the question before this court is simply whether the jury gets the accurate state of the law or they do not.
You may respond.
Thank you.
Ms. Paddock.
What the state argues is actually incorrect. The issue is regarding admissibility. So this instruction is only relevant for admissibility. If there was no corpus delicti, then none of the defendant's confessions could even be admitted at all. You would have been precluded from admitting them to even let the jury hear about them. What the defense's concern is now is that this is improperly impeding upon their duty to find guilt beyond a reasonable doubt. This is infringing upon that standard. There is absolutely no law that talks about the fact that you do not have to corroborate a defendant's confession in terms of a jury verdict with beyond a reasonable doubt as a standard. And I would like to use the example. There is one situation, that is the Gaxiola case. And the Gaxiola case, I believe, oh, here it is, I have the site. 121 Nevada 638 from 2005. The testimony of a victim of sexual assault does not need to be corroborated, and that is entirely different than the situation in this case. The confessions were admitted into evidence. That was correct. They absolutely can be admitted into evidence, but this instruction improperly instructs the jury that there's arguments by the state, arguments by the defense, that they get to consider. They get to consider all of the evidence, and we cannot interfere with the burden of proof. So the state is wrong.
So, Your Honor, if I may be heard, like Sefton is not about admissibility. Sefton doesn't say this is about admissibility. It is about the threshold of proof, which is here. Now, if the court wants to add, it's still up to the jury to determine what weight to give to a statement. That's fine. But in terms of like the inaccurate statement of law being offered
Where
to the jury,
in Sefton does it say a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime?
okay, it's if you do a Control F cert, F5 if you want it, if you're there.
Sure.
It says use conviction based on a confession will stand, although it is uncorroborated otherwise than by proof of the corpus delicti.
It doesn't cite to any other cases.
Actually, it does. In footnote 41, it goes on to say, it says, to this text, many authorities in support of this rule, and where corroborated evidence has been adduced, the rule is further stated. The corroborating evidence need not be such as to connect the accused with the crime. And then it goes on to say, hundreds of cases supports this rule and are cited in this note.
I believe Doyle supersedes that.
All right, let's look at Doyle.
And again, Doyle is
a kidnapping case.
They're talking about specifically a kidnapping case. or kidnapping charge. It's a murder case, but a kidnapping charge is where the corpus comes in.
I don't think that matters.
Instructing a Gaxiola, but not instructing this case.
The West case that you guys both agree on, let's talk about that maybe.
Okay, well-
So that is clearly, that's a no body homicide, correct? Brookie West, right? That's
Yes,
what
there
you're
was
citing?
no body in that
Okay.
case.
So obviously a very different situation.
And that's just the two precedent factors that the state has to independently prove, which is the fact of death and the death occurred by the agency of another.
And I don't want to jump in, but she mentioned Gaxiola. Why would we be entitled to instruct a jury that a victim's sex assault cannot be corroborated, but we can't instruct that in a defendant's statement? Gaxiola supports the argument.
And this isn't an attempt to change the burden. If the court wants to add to this that the state still needs to prove the case beyond a reasonable doubt, or it's up to the jury to give what weight it wants to give to the statements, that's fine too. But it is axiomatic that we do not have to corroborate a confession.
Whoa, big
And
word
the
alert.
law supports that position, and Mr. Samt has told the jury
Axiomatic?
different, which is not true.
Red pen. What would you rate that word on a scale of 1 to 10? Axiomatic. I heard axiomatic, like the axis. I'm guessing that it means something along the lines of crucial or pivotal, but axiomatic. I would ask Siri, but Siri has a history of thinking I meant something else, and yes, it would probably say something about climax in there that I don't want it to tell me. Ooh, self-evidence. That's a good one. So the Founding Fathers could have said, we hold these truths to be
So really the
axiomatic.
argument here boils down to whether the defendant's statements need to be corroborated by any evidence, or in the case of the misconduct is stating it needs to be slight or prima facie for the kidnapping.
Well, that is regarding whether the crime occurred. That's not even about whether or not his the statement.
Right. Okay. Because when in the kidnapping context, there's a situation where that crime could have not occurred.
Right.
There could have been no kidnapping whatsoever. It could have been a complete fallacy, a complete made-up situation. Whereas when we're talking about a homicide, there is proof of corpus automatic within the body existing.
Correct.
Okay.
Doyle is just not used in kidnapping cases. That's the standard that's been used since it came out. Everyone cites to Doyle. Doyle is the standard for the corpus delicti rule.
Not according to West, which says the corpus delicti rule in Nevada is well established. To prove that a murder has been committed, the state must demonstrate the fact of death and the death occurred a criminal agency of another. So that's what we got to establish. And then independently. And then the only question is, do we have to corroborate anything else or not? And the law is clear. We don't have to corroborate anything else. Now, of course, Ms. Paddock does have a fair point. They're not required to accept it. But we're also not required to corroborate it. And that's the impression that the jury was given by Mr. Sanf when he said, you are required to corroborate it. We know that's not the law.
A defendant's statements essentially, if believed, kind of borrowing that phrase from Gaxiola.
Okay, yes. If believed, that is fine. I think that's fair. They don't have to believe it. I'm not trying to communicate that. I'm saying they don't have to believe it, but they don't have to corroborate it.
The defense still believes that also in West, it says corpus delicti must be established before evidence of a confession or admission may be considered to prove that the accused was the criminal agency that caused the victim's death.
Yes.
So the defense maintains this is a question of admissibility, not a question of fact for the jury. It doesn't apply. And
You just stated that in order to get into the statement, you have to show that a crime has been committed. And the state did that because we have a body. That's literally the corpus. So a corpus is beyond approved, right?
Correct.
So Brookie West is totally different because Brookie West, there's no body. And so how do we know that it's a crime? Those are all the issues. Here we have a body, always had a body.
I know, but I don't think the instruction should be given because it was not an issue in this trial.
Corroboration.
You admitted the confessions. This would be an issue to keep the confessions out of the jury's hearing. But here, they got to hear all the confessions. So now we're infringing upon the right of counsel to argue their case in front of the jury and the right of the jury to make the decision, the duty of the jury to make their decision beyond a reasonable doubt. This instruction should not be given at all.
All right, so
I'm sorry.
you might want to just listen for a second, Mr. Paul. Okay, so the
She
state's
says, "Shut up. You're winning.
instruction,
You're winning. Sit down. Shut up."
I believe, is in reading through and reconciling it with Sefton versus State, as well as the reiteration in the Brookie West case, is a correct statement of the law. However, I think the arguments of defense and everyone has been that these statements are not to be believed. And so I think the if believed language borrowed from Gaxiola adds that component in. So what I'm going to do on this instruction is say where independent evidence establishes the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime.
Your Honor, so you're going off of the state's?
Correct.
Can you do it a little bit slower, please?
Absolutely. I'm going to send you guys a copy of everything, but
this is a
where
big win for the
independent
state.
evidence
Big win.
establishes that the victim's death was caused by the criminal agency of another, and just paraphrasing, that is directly from West, a defendant's own statements, if believed, admitting the crime, need not be further corroborated by evidence connecting the defendant to that crime.
Are you going to add any of this defense proposed the defense proposed instruction?
So, the defense. Well, the defense proposed instruction says there needs to be slight corroborating evidence independent of any confession or admission, but that ultimately goes to the crime, to whether corpus is established. So the first paragraph is, or the first line is literally saying where corpus is established, but explaining what corpus is. So I don't think that there's any way, given the court's ruling, to include that a slight or prima facie showing permitting the reasonable inference that a crime was committed is sufficient, because that would be impeding essentially on the corpus determination, which we've all agreed in this case is established. There need not be. And additionally, the final line of what this defense has proposed does say there need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confession or admissions. Is that something that you're seeking to have added, Ms. Panduct?
I moved to have the entire
okay.
instruction, and I would ask that any part of it still be given because I believe it is more informative and less confusing and misleading than the instruction that the state is proposing.
Okay. Any objection to the final line being added?
Yeah, I think it actually confuses the instruction as currently given. There need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confessions or admission. To me, is less clear than defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I think our language is far clearer for the jury, and I think this is more duplicative than anything else.
I also believe that there should be a reasonable doubt admonition then as well placed in here. I believe this is still confusing to the jury, and the defense should be able to do the arguments as they intended.
What's the proposal to add a reasonable doubt instruction into this instruction?
If believed.
Or is that something that you
I would ask
could be fixed by putting it close to the reasonable? Well, what are you asking?
No, I would ask that in this instruction, right after here, that it is up to the jury to determine the weight to be given to the confessions or admissions, and they must determine beyond a reasonable doubt
I don't have a problem.
But definitely wait.
Yes.
It's up to the jury to determine the weight to be given any statement or any confession or admission.
I think that's a fair statement of the law, and so I don't have any objection to that.
Okay.
All right, so that instruction will read as follows. Where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. It is up to the jury to determine the weight to be given to any confession or admission.
That's not the statement.
Okay. Obviously, over objection, but incorporating some of the defenses, that is how that suggestions, that is how that will be given. And then the final issue we have before we dive into just going through the instructions one by one would be the argument regarding self-defense. My initial reaction when you said this was self-defense is ultimately a defense. And so all of the instructions in Runyon go to the amount, or whether they're given, goes to the amount of evidence that a defendant presents and that a defendant argues. And I've never seen it given over the objection of the defendant.
Well, while I appreciate that, and I know Mr. Shamp has made a number of arguments to this jury, there is evidence of self-defense present, and the state is required to rebut that evidence beyond a reasonable doubt. Part of that evidence of self-defense involves him being the initial aggressor. So the jury has to know that while he may have asserted self-defense, let's say they only believe the book version, right? Or they reject everything else and only believe the book version. The book version is it was committed in self-defense, right? It's sort of like the mere presence instruction that's in here. The 2009 statement is more, I'm merely present at this particular event. Both the 2017 and the 2019 book is like Tupac shooting at us, so someone from the back seat started busting. Okay, well, Tupac would have been allowed to shoot at you. I know that there isn't a lot of evidence to support that, but the jury needs to be instructed on what the elements of self-defense are, because one of defendant's defenses, not Mr. Sham's, but defendant himself, in his own statements, his defense is self-defense. And so we're entitled to have a proper instruction of that isn't self-defense. Even if you believe what he says only in the book, that is not self-defense.
But in order for you to tie Mr. Davis into this event whatsoever, there has to be an overarching plan already at the time that the self-defense came in.
I agree. That's why legally, right? Legally, he's wrong, right? He doesn't know the law of self-defense, but a lot of defendants give confessions and statements and go, hey, it was in self-defense when they ran up on somebody with a gun and that guy pulled the gun out and shot at them and hit the woman behind them, right? I mean, that case we have right now. That defendant says, oh, I committed the crime in self-defense. Well, as a matter of law, you ran up with a gun on somebody, you don't get to claim self-defense. So the jury needs to be instructed on what the law of self-defense is, because there is some evidence of self-defense in the case. Whether the defense is going with that defense or not, whether Mr. Shamp argues it was in self-defense or not, isn't relevant. The law is, if there's evidence of self-defense present, the state must disprove it beyond a reasonable doubt. And since the defendant has asserted in at least two statements that the car was acting in self-defense, the jury's entitled to know what the law of self-defense is.
Hello?
Remind me, does he actually say
He says the word self-defense.
self-defense, or does he say that, we thought he was going to get to popping or something like that?
No, at one point he says...
I'm confusing it with a different statement.
At one point he
There were
says,
several.
and I can't remember if it's in 2017, I think it's in the 2017 audio recordings, where he tells Mr. Diaz, yeah, it was in self-defense. He actually uses the word. I can word search the various statements, but when I heard that, that's what caused me to go, wait a second, we need to put an instruction in here, because...
Okay, so I guess I see where you're coming from now. Defense, what's your position regarding this?
First of all, I would note that if the state brings these instructions in, they're adding to their burden of proof at trial because they have then the burden of proving that the defendant did not act in self-defense. So I don't know why the state would want to add to their burden if the defense is not even requesting.
Leave that on them. You don't have to worry about that anymore.
That I don't understand.
Okay.
We're not asking for those instructions because we are not going to be arguing self-defense. We believe it would be confusing to the jury. It certainly is an accurate statement of the law under Runyon, but also under Runyon, it's up to the defense to ask for those instructions. I don't know of there being any case where the state can ask for them when the defense has not, but in the end, the defense will submit that to your honor.
Okay. Final word, state?
Yeah, it's in 2017 where Mr. Diaz is, so you're saying it's in self-defense is what really happened, and Davis says, yeah.
So Mr. Diaz says that.
Well, he uses the word self-defense, but I mean the description of what Mr. Davis is saying is, hey man, Tupac pulled out a gun and started shooting at us, and so we had to shoot back. And so Diaz is saying, so you're now saying it's in self-defense, and the defendant says, yeah.
I mean, Ms. Pandak brought up a good point. I don't know why you'd want to take on a burden of disproving something that they're not even raising, but...
Well, that's on me, though, right?
Yeah. All right, I'll give you the Runyon instructions. So we've gone through voluntariness of statement. That was granted. We're going to give instructions on that. Over state's objection, we've gone through corpus delicti. That was given over defense objection, and then self-defense is sort of, you're asking to take this on, and we're not sure why, but you want it, so we're going to give it to you. All right.
Also, for the record, I don't know if I made this record earlier, but there were wordings in the state's proposed instruction that I suggested making some additions, and the state granted that, and they made all the additions that I requested to other instructions, so I don't think we need to make a record as to those specific...
Except for she doesn't have those in front of her. I have been taking down notes of everything you said. I now have a clean copy with our instructions in order as it relates to the voluntariness. How about I save these, send them to the court, and we use those
Oh, you don't do that in every other case. How come I have to do it in every other case? Anyway, okay, just kidding. All right, so at this point, I'm going to have you email all the parties with the notes that you've taken. We'll review them, and then we'll go through one by one, making sure there are no further objections. While you're doing that, any way you can make page 3?
I can't. I mean, maybe.
Yes, to
maybe
not
Ann
more.
can get page 3 to get that word off. I couldn't figure out how to
Question
get.
on that. Determine whether or not the defendant is guilty of one or more of the offenses charged.
Guilty, I guess.
Of the offense charged? Because
Of the event. Yeah. Yeah. Well, that'll solve it.
Okay.
Or just don't make it an extra.
Of the offense charged.
Or make it small.
Guilty of one or more of the.
Okay, if you do guilty of the offense charged, it actually fixes the issue.
It does.
Okay. So
Let me
that was
save
just us
this as
being
the final.
style wonks. All right. Send it over.
That's charged. Okay.
Yeah. Before I make sure I did put those Passimo ones in here. And there's self-defense. Come on.
So the one that you sent me at 9:13 a.m.
Didn't have the self-defense ones in them, or not the. It didn't have the Passimo ones in it in place.
Okay.
So that's why I added those. Proffer agreement, statement. One statement made during police interview. Okay, yeah, they're in here. Okay, this is ready to go. I'm emailing it now.
Thank you. Do you have the Bolden instruction in there somewhere?
Everybody is
There
scrolling so aggressively.
Multiple
on
versions
their
of Bolden
mouses.
in there.
this.
Do you want to send it? Do you want me to send it to Ann too?
No, I'm going to print it out myself.
Spock's family showed up to court today. Pretty much nobody else did. A couple
And
interested
you're getting rid
parties.
of the sites on the Sefton and West piece, obviously.
Oh, did you have sites on there? Hold on a second before I do this then. Oops.
Is there a playback in here too somewhere?
There is.
Okay.
Okay. I think it's good now. Let's see. Go back to tree instructions. Insert. Okay. I think these are all right. People check. Mike, I didn't send it to you. I sent it to Megan. I sent it to Colleen and Megan.
How dare you?
Because I know you don't even know how to open your email.
Well, I have it open. It's waiting for it right now.
Oh, well, you want me to forward it to you right now?
No, I don't want to read it.
He's
That whole
notorious
law
for
thing
not
gets in the way of what we do.
Words.
not reading his email or not getting his email.
So then just do a final run through. I'll let you read through and make sure that that's what you've agreed to, or what you've all either made a record on, and I've ultimately made a determination of misconduct. Okay.
Okay.
And then I'll number it if that accurately reflects what we have done here. Okay. So it is now my duty as judge. Any objection?
Judge, they don't have a copy.
Oh.
So, I mean, I emailed it to them, but they don't have a computer.
No.
Oh.
So can we print a couple of copies? We'll just do it manually.
That would be great.
Sorry, trees. Okay. Did you get an email to you?
It's
Okay, I'm
totally
gonna forward
Colleen.
it.
You're so non-green.
Defense is not yet in the digital age.
I'm very old school.
This is a 30-year-old case. You can't blame him.
I'm just gonna go print and back. It's fine. I'll be back. Thank you. You're welcome.
Get to keep the rare hot mic while the judge is out of the room.
I'll give you a new copy of our brief.
I love these.
This is only the second trial where the voluntariness of a defendant's confession has ever been submitted to a jury.
Really?
125 trials in, only one other time have I had somebody ask for it.
I've always asked.
And in
I've
that
always
case,
included it.
the defendant did get on the stand and said they beat me with rubber hoses.
I've always included it.
Okay, we lose the hot mic. There's the Tupac's family there on the front row. They've been present for all of court, the whole trial. Wait for the judge to finish printing this off and bring it back in. Some pretty spicy litigation back and forth here. Little arguing. Ooh, Monster Energy. Monster Energy and Dasani are the two drinks of choice there. What's the state drink? Is that a Dr. Pepper? And water. And just Costco water. He says, no, you drink your water, I've got Monster. Lizzie Yordi, been absent for LC, so ready to be back with y'all. Can't wait. It's going to be fun. Hopefully the verdict comes in. We can have a big old welcome back party. Lizzie. 38 months makes you an OG. Thank you very much. Not sure how long it takes to print and collate this document, but the judge is handling it herself. So, because defense doesn't have a laptop. Whoa, officer involved shooting. Let's see, yesterday in Asheville, North Carolina. Sorry, just trying to keep up to date with everything that's going on here. Cat Not Williams on Twitter was just tweeting about a story.
Hello?
Uniqua Teal. Oh, never mind. Judge is back. It's in my hometown here, Greenville, North Carolina.
Thank you. Okay. Thank you. Does anyone need clips?
I would.
I didn't bring a pen. Oh, yes, I did.
Give one to me. Okay.
Although such a good, we gotta find a pen. We didn't plan on selling trees today.
Yeah. One of you brought no pens, one of you brought no computer. There's something here, but all right. I'm too tired to make the connection. Okay, let's go through then one by one and see if there's an objection. I will number them as we go, and then you will have a complete set, I think.
Thank you.
Okay. It is now my duty as judge. Any objection?
No.
No.
That'll be one. If in these instructions any rule, direction, or idea is repeated,
No objection.
that will be given as 2. An indictment is but a formal method of accusing.
No objection.
No objection.
That will be given as 3. A conspiracy is an agreement.
No objection.
No objection.
That will be given as 4. It is not necessary in proving a conspiracy.
No objection.
That will be given as 5.
Thank you, Hannah. I love them too.
Each member of a criminal conspiracy is liable.
No objection.
That will be given as 6.
That means he doesn't have to
If
be
one
the
member of
shooter.
a conspiracy withdraws.
No objection.
That will be 7. Evidence that a person is in the company.
No objection.
That will be given as 8. When 2 or more persons are accused of committing a crime together.
No objection.
That will be given as 9. Murder in the first degree
No objection.
I think that should be is a specific offense crime.
Yes.
That's correct. It should be.
Okay.
Is a
Specific offense crime, not, yeah. No S on crimes.
yes.
Murder in the second degree may be a general intent crime. Okay.
And that is number,
Actually, murder in the first degree shouldn't it be specific intent crime?
Yes.
yeah, specific intent, not specific offense.
Yes.
Specific intent crime.
Yes.
And you're gonna clean these all up for the next time I use them.
All right. The next one. In this case, the defendant is
Was that
accused.
10, Judge?
That is 10.
Okay.
In this case, the defendant is accused in an indictment.
No objection.
That will be 11. Murder is the unlawful killing of a human being.
No objection.
That will be 12. Malice aforethought means the intentional doing of a wrongful act.
No objection.
No objection.
What number would that be?
13.
13. Okay. Express malice is that deliberate intention.
No objection.
No objection.
14. Murder of the first degree is murder.
No objection.
No objection.
That'll be 15. And now we're into the Byford series. The law does not undertake to measure in units of time.
No objection.
No objection.
That'll be 16. Although your verdict must be unanimous as to the charge.
No objection.
17. The next one is you are instructed if you find the state has established.
No objection.
No objection.
That will be 18. All murder which is not murder of the first degree is murder of the second degree.
No objection.
No objection. Oh, I'm sorry. No objection.
Is that 19?
That was 18.
18?
18.
Thank you.
No, that last one was 18.
Yep.
So this
Okay.
is
Also, no,
19.
murder, which is not first.
Is second is 18.
No.
It's 19, I'm sorry.
Is 19.
All murder is 19. We on the
Great.
same page?
The killing of another person in self-defense.
So we're getting these?
Yes.
Okay. I will rely on my previous objection.
Of
for the
course.
record.
But you agree that's what we've agreed to essentially.
Yes.
All right. So that'll be 20.
These are correct statements. of
These
the
are
law.
all Runyon. A bare fear of death. Another Runyon instruction will be given as 21.
Yes.
An honest but unreasonable belief in the necessity for self-defense. That will be given as 22. The right to self-defense is not available to an original aggressor. Will be given as 23. Actual danger is not necessary to justify killing in self-defense. Will be given as 24. The killing is justified even if it developed afterwards. The person killing was mistaken. Will be 25. If evidence of self-defense is present, state must prove beyond reasonable doubt the defendant did not act in self-defense. Will be given as 26. If a person kills another in self-defense, it must appear. Will be given as 27. And then we're out of the Runyon series.
Okay.
Okay. Then we're into the deadly weapon enhancement. You're instructed if you find defendant guilty of first or second degree murder, you must also determine whether a deadly weapon was used.
No objection.
No objection. 28.
That'll be 28. Deadly weapon means
No objection.
29. That's 29. State is not required to have recovered the deadly weapon.
No objection.
That will be given as 30. If more than one person commits a crime,
No objection.
that'll be given as 31 to constitute the crime charged.
No objection.
That'll be given as 32. Defendant is presumed innocent.
Can we slow down just a little bit? You're faster than my fingers.
I just wanted to make sure we took out this one word. Okay, no objection, as revised. 33?
That'll be given as 33.
Yes, sir.
You guys have met and conferred about that and come up with this.
Yes, we took out the word material pursuant to the Burnside case.
That's
okay,
correct.
Perfect. You're here to determine if defendant is guilty.
This was an instruction that the defense offered a revised version, and the state agreed. So,
So this will be given as 34 as
Thank
modified. The evidence you are to consider in this case,
no objection.
that'll be given as 36.
No, 35.
35, Judge.
Thank you. That'll be 35. It is a constitutional right of the defendant. He may not be compelled to testify.
No objection.
And to be clear, you are requesting that.
Yes.
Okay, that'll be given as 36. You heard evidence regarding drug trafficking, federal convictions, and gang affiliation. This is our Tavares instruction, correct?
Correct.
Okay, that one will be given as 37.
And Your Honor, just for the record, similarly to some of the other ones, Ms. Panduct asked us to revise it a little bit, and we agreed to her revisions.
Okay, perfect. Thank you for putting that on the record. The next one is a proffer agreement is a contractual agreement between a sovereign and a defendant that obligates the sovereign and the defendant to its terms.
Your Honor, we discussed this. My concern was with the word sovereign, that the jury may not understand that. And so there was some discussion about changing that word to jurisdiction or government. But
How about like a specific government entity? Is that better, or? But I mean,
I don't know if the court has a similar concern.
Sovereign always reminds me of a sovereign citizen.
I know.
You can use whatever term, like a specific government entity.
Okay.
I think that would be better.
All right. So if you guys want to replace the word sovereign with specific government entity, it does. So it would read: a proffer agreement is a contractual agreement between a specific government and governmental entity and a defendant that obligates that government entity and that defendant to its terms, wherein both sides of the contract expect the benefit in exchange for entering into the contract. It does not bind any other government entity. In this case, you have heard that the defendant entered through. Do you want to spell out count through?
Oh, yes, it should be spelled.
Instead of like a drive-through at McDonald's, like the actual way the word is spelled, guys. All right. Through counsel into an agreement with the United States government. The state of Nevada is not bound by that agreement. So there's no objection to that with the replacement of the word sovereign.
Yes.
Okay.
That is.
I'll give that one as 38.
Yeah, I heard that, Hannah. That was funny.
A statement need not made by the defendant himself to be considered his own statement.
No objection.
That will be 39. Statements defendant made during a police interview. That is,
Okay.
This is going to be 40. We have discussed it. Your prior objections stand, but ultimately your request for instructions on voluntariness are acknowledged and given.
Thank you.
All right, and then the next one.
Just for the record, the state does.
And the state objects to the giving of them, but got their wording.
Correct.
Okay. So that was given as 40. And then the next one is in the same vein. In making a decision about the voluntariness of a confession or admission, this will be given as 41, pursuant to our previous argument. The next one is where independent evidence establishes.
Let me read this more carefully.
This is the corpus one. We called it corpus, but I disagree. It's really corpus.
the corroboration one.
Corroboration construction. Let's call it that.
Our objection stands.
Okay, but you agree that's what we decided on.
The court decided on.
Okay, so that will be given as 42. Previous objections are noted. The next one, wherever there is slight evidence that a conspiracy existed.
Okay. I usually put this one earlier, but let's just keep it where it is. Okay, 40. No objection.
That'll be 43. In deciding the facts, you may have to decide which testimony to believe.
No objection.
This will be given as instruction 44. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness.
No objection.
That will be given as 45.
Hold on.
Although you are to consider only the evidence in reaching a verdict, you must bring your common sense.
No objection.
That will be given as 46. During this trial, you received certain audio recordings.
No
And
objection.
It explains that the audio recordings are the evidence as opposed to the transcriptions, which may contain errors.
No objection.
That'll be 47. The next one is you may not discuss punishment.
This is one that I asked for alternative language to be used, and the state agreed.
Okay, so as modified, it will be given as 48. When you retire, you must select a foreperson.
No objection.
That will be 49. In your deliberation, you desire to be further informed on any point of law.
Objection.
This is the playback. So,
hold on. So 50, no objection. And then 51.
we need the instruction in there that the jury is not to test any theory of the case, etc.
Oh, yeah, I always forget that now. There's a court rule for that. So maybe we should add that before 51.
Okay, let me pull up.
Or make it 51.
Let me pull up the ones that I've used for previous cases.
Wait a minute. Hold on.
Oh, okay. I'm realizing at this point that we're missing one.
I feel like we're missing one too.
We are, and she's grabbing it. It's the one where they're not supposed to do any research or look on social media and all the other stuff that the court requires us to do.
And I haven't finished with going through them, but I realized at that point that we were missing that one. The Bowman instruction.
Which is going to be 51. I'll add it as actually. Page break. I think the court typed that one for me in our last trial. Let's see. Aubrey? I have to bring up that.
Please don't mention that right now.
Please don't mention that right now.
Using that one.
Those instructions work great.
Very efficient
Where is that?
process to get the instructions hammered out. We've only been running for about an hour, hour and a half.
You guys have the credibility instruction in there?
Yeah.
Yeah, it's the lengthy one. It's not the short one.
All right, so the
Okay,
Bowman
we wanted the
instruction
short
needs
one
to be
again.
given, which states, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. Read, watch, or listen to any news or media accounts or commentary on the case. Do any research such as consulting dictionaries, using the internet, or using reference materials. Make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own. Any objection to that wording of the Bowman instruction? I think
Which
that's...
instruction is this?
It's the instruction from...
Which number though?
I'm
will
going
be
to have to
51.
add it in. We don't have it. It's from Bowman versus State. In 2016, the Nevada Supreme Court indicated it was... First of all, that I had to read the admonition that I do every single time they leave the
Could you
room.
restate it? I just noticed a
Absolutely.
missing instruction that I thought was in there.
Okay. During deliberations, other than deliberating with each other in the deliberation room, jurors are not to, 1, communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. 2, read, watch, or listen to any news or media accounts or commentary about the case. 3, do any research, such as consulting dictionaries, using the internet, or using reference materials. 4, make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own.
No objection.
Okay.
And what number? That's
We can just make it 51.
And then I'm emailing it to you, Mr. DiGiacomo.
Oh, I just, the beginning of the one we used last time was slightly different. So it's during deliberations. Just read me that, and I have it in here already.
During deliberations, other than deliberating with each other in the deliberation room, jurors
Deliberating
with each other in the
deliberation
room,
comma.
jurors are not to, colon,
Or not to. Okay.
all the things. Okay, so that'll be 51. Is that the idea?
and then the
That would
last
make
one will be
sense.
52.
Yes, so we'll put the Bowman instruction as 51, and then 52 will be, now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict.
I just
And that would be 52.
There was an instruction that was omitted from these, so the state presented a different credibility instruction.
Okay.
But I thought that this one, which is a stock instruction, would be included, and I see now that it is not. It's the credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness has lied about any material fact in this case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. That is a stock instruction.
Any objection to using that instruction as opposed to the one that you've included? It's
At 44. If you want to replace that in 44,
Yeah.
I have no objection to
Okay.
that.
And I also don't mind using both of them.
Well, I mean,
We
there's
need one.
duplicative. We need one. So, if you want to
if
use.
that's your request for that instruction, Ms. Pandek, that's the one we'll use.
Thank you.
If you want to just give that wording to Mr. DiGiacomo. Or he has
I
to
actually
type it
can
up.
get it
Can you
because
get it?
What
It's the one he's used.
What happens
in every,
is the court.
He's used that in every other trial and objected to this one, but today he decided to switch it up on me. So
Yes,
I'm glad I saw it. You're fine. Okay.
Yeah, Judge, just because I stole these instructions from ones you made me do last time, so I'm like, I'm not even going to fight this time. Ability of a witness should be determined by his manner.
We're hearing him type.
Okay, so while he's working on that, the state has proposed the verdict instruction, so the verdict form, so I assume they have no objection to it. Ms. Panic, any objection to the form of verdict?
Mr. Samt had requested that not guilty be listed first. I told Mr. Giacomo he did not agree.
We object.
In general, in most cases, I have no objection to doing it that way, but because of the way that the step-down instruction works, it makes sense in homicides to have it in this order. And so I understand the objection, and I understand why it's been upheld multiple times going in the descending order. Essentially, it converts the step-down instruction to a step-up instruction, and so that's generally why I don't do it in these cases. But all right, so other than that objection,
Yes.
the crimes included are the crimes you're requesting to be included.
Yes, we did not request a voluntary manslaughter to be
Okay. That's on record. All right, Mr. DiGiacomo, then do you have
So no lesser included?
everything added to yours?
I'm still typing that, Judge.
Okay, perfect.
But as soon as I do, I will send it to you.
What, Mr. Prosecutor, do you bill per hour for typing up jury instructions?
Okay, I think save as, final numbered,
Final number jury instructions.
and I can send this around to everybody.
Save it to the desktop where
Okay,
everything
sounds
should be
good.
saved to.
Anything else we need to address while we have this time before we do closings on Monday?
We'll be at 9 o'clock as opposed to 9:30?
We hope.
I think the idea is we're having everyone get here at 9, but if we ultimately start a little later, that may be what ends up happening. But I also have to read instructions, which takes about, with 52 instructions, we're thinking maybe 20 to 30 minutes. So I don't think that we would be starting actual argument until about 9:30, at least. Mr. Sam?
I'm sorry, Judge. I don't remember in this department. Do you give each one of them a copy of the instructions to follow along with?
So what I do is I read the instructions to them and tell them to write down the ones that they want, and then we give 6 copies in the back.
I see. All right.
Okay.
Thank you.
Anything else?
Nothing from the state, Your Honor.
Nothing from defense?
No, Your Honor.
All right, we'll be in recess. We'll see everyone back on Monday for closing arguments. Thank you, everyone. Have a good weekend.
Monday. Judge, have a good one. Have a great weekend. You've earned it. Thank you very much. Appreciate it. A sometimes tedious portion of the trial, but also very, very critical portion of the trial, as we saw from the vigorous argument on both sides as they argued key issues such as should the jury be instructed that the state has to corroborate witness statements, confessions with other evidence. This is important stuff. These are the tools, the instructions the jury will use to make their decision. So cases can be won and lost in this moment. And state won some crucial ones, and defense won a couple as well. So a very interesting day that way. Love to see that go down. Yeah, he's on salary, so he doesn't get any extra for typing it. You're right, Lacey. Keith did waive his appearance today. He's watching from home, from his cell. Excuse me. As soon as they get ahead of schedule, they start taking short days. Yes, they want to fall back behind. The thing is, if the way courts work, when you have to have notice, right? You have to have scheduling. You have to plan out ahead of time. You have to let the witnesses know what days they're going to be there and when the court case is going to be. And sometimes notice has to be given to the victims and everything else. There's a lot. There's a lot of planning that goes into it. When cases wrap up early, it's very difficult for the judge to take significant amounts of her workload and just say, well, we'll just pull this forward. let's do that tomorrow. No, you can't do that. You just have downtime. And maybe she would be able to absorb some of the docket work another judge has if they're falling behind a little bit, or cover for somebody whose trial's gone a little bit longer. But judges like to stay on schedule. But for the jury, they're okay if it's ahead. R.A., are you surprised Caden wasn't called? I think a lot of people could have been called. Caden was in Canada, right? He's in the true north, bold and free, which apparently we're at war with. I mean, Pickles not politics, but I don't know why we can't all get along. We share this rock, and it's all the same sunshine shining down on us. But we'll save that for another channel to argue over. I would have liked to have heard from a couple other people in this one. I would have liked to have heard from Shug. I know that's an impossibility, but that would have been telling maybe a couple people in the entourage, in Shug's entourage. And I'd like to have heard a little bit more, other than just from a couple girls who were like, yeah, we're going to party with Tupac. Would have been interesting. All right, it is 1:45. I'm just looking right here. 4 o'clock Eastern. Well, let's see. When does this meeting start? Did I miss it already? 7 a.m. to 11 a.m. I think I might have missed it. What time did they say this starts? Hang on one second. Tell me I didn't miss Corey Richens. Okay, 1:30 p.m. Mountain Time, which is in 2 hours, right? Yeah. In 2 hours, there is a hearing on WebEx that, and I'll read you the information we got directly from the court PIO. It says, let's see, 8/28, that's today, at 1:30 p.m., case number 231500139, Corey Richens, aggravated murder, attempted criminal homicide, false insurance claim, forgery, restitution hearing. So this is, I told you it was the new case. This is the restitution hearing for the original case. Judge Mrazek, park record is still a photography pool, law and crime is pool for WebEx feed only, no live streaming, link in comments. So I've got the link for the WebEx. I cannot live stream it. I can record it. It's my understanding we could play it back at a time when it's not live. Which, for my personal understanding about Judge Mrazek, he considers that to be, you can play it back after court has concluded. That's my understanding of his understanding of those words from his previous orders, which I've been present in his court for. Amber says, I'm beyond disappointed in the state's case here. Regardless of a verdict, this has to be all the state put on, and then no rebuttal. Just terrible. Yeah, I mean, they ended their big ending for the state was, we tried to get these other people, and we failed. But we tried, but we failed. And they are pinning all of this. They're pinning this entire thing on jury. Please believe Mr. Duane Davis. Believe Keefe D. Believe the story, the version of the story that he told that we want you to believe, but believe Keefe D. And all defense has to do is prove that he's a liar, which is pretty easy when he's got conflicting statements admitted into evidence. I don't know. This might be a difficult one for the state to get a win on. Even though, in your heart of hearts, you might see, yeah, This seems like a no-brainer. The defense witness was a good witness for the state. The last one that the state flipped, they did a good job with him, actually. I disagree because they've got a confession from the defendant. Why complicate your case when you have a confession? There was also testimony that they had confessions from a lot of other people, too. I don't think Bill Clinton submitted his own, but somebody submitted a tip that maybe Bill Clinton had done it. We know that didn't happen, right? But they're in possession of confessions or tips from people saying that they were responsible for it, and they clearly weren't. Let's see. Was anyone alive? Love True Crimes. I think there were people alive in Suge's entourage. There are plenty of people in the cars behind him. We've heard from a couple. I think we heard from one, maybe two of them, but nobody who was able to do any identifying of the shooter. Yeah, sorry, but that Bill Clinton comment highlighted the loonies come out to confess. They do. Big trials, big interest brings big crazy. He confessed multiple times, but the other confessions didn't meet the proof or match what happened. Well, Keefe D did match what happened. Not all of them, obviously, but most. He did, I would say, provide information that was remarkably consistent with the evidence as it was developed, and that's what gives it credibility. So I think he's going down for this one personally. It's good to be hard on the state when they're trying to lock citizens away. I agree. I think the burden that the state carries is a difficult burden, and it's designed to be difficult. I am not of the mindset that, oh no, what if a bad guy goes free? That's the wrong way to look at that, in my opinion. I'm much more of the mindset, oh no, what if a good guy gets convicted? I'd rather have more bad guys go free than one good guy get convicted. All right, has everybody had lunch and you just ate without me? Is that what happens? Because I see everyone's just like kicking back and taking it easy this afternoon, which is great. I like that. I'm trying to think what we want to do with Corey Richens this afternoon.
I was kicked back, taking it easy.
I don't know how long it's slated for, but it's a Friday. It starts at 1:30 p.m. It's just restitution hearing. I'm drinking lunch. Clever name is, I guess it's not too early to start. I need lunch and more caffeine, says Hannah. Last bite of lunch went down right when you asked. What did everyone eat? I missed it. I couldn't even smell any food cooking. Are you going to do a poll for how long the jury will be out after closing? Hannah, I think we will. We haven't done a poll yet for our group that's watching this of whether or not he's guilty or not. I skipped that on Friday, but I wasn't going to do it today because a lot of people who are following the trial aren't with us because they're off doing other things or getting ready for the weekend. But hamburger, bacon, and cheese. Oh, that is yummy. I was going to save it for the podcast, but now that you guys are starting to mention food, there was this little story that came across the wire not too long ago. Actually, earlier today, Northeast Houston father says he was stunned after checking his Ring camera, seeing the DoorDash driver who had just delivered his food standing outside his home. Now, that in and of itself is not... Oh, wait, I missed two words. Completely naked. Sorry, I ended early. The completely naked part. It's on Ring camera. It's on Ring. DoorDash, apparently, sans clothing delivery. I think I lost my appetite, for at least I would not eat anything that came. Oh, my goodness. Oh, joy. Yeah. That can't be legal. I mean, maybe up in Oregon or Washington, they have some weird laws on nudity up there, I think. I'm sorry, I'm not throwing you under the bus, Pacific Northwest, but y'all have some weird laws up there. but I'm pretty sure DoorDash. How was he at the restaurant? That's the question. Related. It was very casual Friday. Extremely. Huge omission. I buried the lead. But yeah, he in his defense, when they say completely, he does have a backpack on. So it's not like bare, but it's just a backpack and maybe shoes. I'm guessing Crocs. How was the order picked up? Maybe he just changed back from being a werewolf. Clever name. I like where you're going with that one. Look, Ma, no clothes. Yeah, everyone's wondering how he picked up the order. Oh, my goodness. Fremont, Washington, clothing optional, especially during full moon. Yeah, that's what I'm talking about. Washington, I think Washington and Oregon both have rules about this. We know because there was a case a while back where I'm not sure if it was parents that were upset or police were upset. Maybe it was neighbors or bus driver. I forget. There was a children's bus stop where the school bus went and parked, and it was either in Washington or Oregon. I'm going to just paint you both with the same brush because you're neighbors. And there was a gentleman who opted to collect his mail from the roadside mailbox in the lean, as you might say. Highly aerodynamic, not encumbered by clothing, and his mail pickup time would coincide the bus pickup time. You could imagine, yeah. Oh, goody, Brian Kober. I think we have some reading to do then. Blue Pen. I think that's. I don't know who Blue Pen is anymore either. You guys, if you had left your pictures the same, I would know. But Blue Pen is Josh. Blue Pen is Josh. I remember that. He was the first. We're blaming him for all of this. Red Pen's actually not even here. Josh, can you send me the link to the notable caseload Idaho thing so I can pull all those? It'll be easier if I do that than trying to email and download and everything. That would be awesome. And let's do some light BK reading after lunch, which I'll make this the portal right now. Let's see. Tyler Robinson. Do we have any BK stuff on here? Blaze Taylor. All right, we'll just make a new one. Boy, yank my computer off the wall. Put a BK thumbnail on there. Wait for it. Okay, I'll fix the thumbnail later. I can't find a good BK thumbnail just yet, but Idaho versus BK. We're going to start that. What time is it now? It's 2 o'clock. That'll take us to 3. Make sure you remind me to grab the Corey Richens thing because I have to wait for the WebEx to start. But so it's 2 o'clock. We're gonna come back at 3 with some light reading. Some light reading about Brian Koberger. Just let that set up for a minute. Thank you, Josh, for that. Appreciate that. Hey, it's freaking hot down here. Where are you at, Karate Cat Mom? What part of the country? I think all of us from central to the East Coast are getting a little bit of a heat wave coming our way in the next week or so. I saw that we're supposed to be back up near 100, and that is too hot for the end of August, the beginning of September. All right, let's do a portal. Told us to change our pictures too. Everyone's. I have no clue who you are. I know red pen and blue pen now, and that's it. We resemble that remark. Washington and Oregon drink the same water. I'm just saying the regionally there are some similarities. That's all. You didn't. I'm guessing you're going to find a pink pen here soon. All right, that's it for right now. We're going to go to lunch. I'm going to get some food because today was shopping day, so the kitchen has been restocked. Water is back on the shelf. We were out this morning, but we have more now. And see, I'm not going to order DoorDash, obviously, because you never know what's going to happen. Poor Ring cameras, man. I don't remember hearing the defense ask for a judgment of acquittal. They did not. They did not. Maybe they should have. Gallons of milk. Yes, I've already sampled it. We have 8 gallons of milk in the fridge. Well, 7.5 now because of the sample. Just the sample size. Tonight when you go home, please hug the people you love. Smile. Let someone make their day just a little bit better. And please stay safe till we go live again in 59 minutes from right now. We're going to portal over there so you can just grab the hand of somebody you know or love and drag them along with you. Make sure they don't miss the afternoon session either. That would be appreciated. And when you land over there, if you can click the like button like you did here before you leave, that would be great. That would be great. So be good, y'all. Go ahead and have second lunches if you've only had the first. But do that. I'm going to have my first, and we'll see you with some Brian Koberger reads. And hopefully I won't fall asleep during them. That would be embarrassing. All right, we'll see you guys in a little bit. Bye-bye.